Yes, Mr. Rao.
With Lordship's kind permission. But yesterday I made a mention about the NCC matter. They are not yet, the counseling is not yet commenced. But I received instruction that they are going to be considering the second phase of counseling. That is maybe Monday or Tuesday. Therefore, the NCC cases will be taken up on Monday, Lordship. Tomorrow I will be find fault with making a submission, Lordship. But they were adjourned after 2 weeks on the request of Lord Additional Solicitor General. They were adjourned after 2 weeks. Well, on factual aspect, there is no dispute. It's only legal aspect. Lordship, please to consider on Monday.
At least fair for whatever there. You have filed an application for vacation.
I filed for application.
That we will consider.
Monday, Lordship, because otherwise they will become infectious.
No, nothing becomes infectious.
4 matters, Lord. 4 matters. 4 matters.
Then other batch.
But these batch, Lord.
Which batch? Today's
Lord, Today batch.
GO challenge to GO 7.
Lord, they are insisting for interim order in the today batch. Lord, my submission, Lordship said.
We will hear, no, Mr.
Yes,
Let
yes.
it be called. We
Yes.
will take it up today.
But I may not
because-
get the counter effect by Monday.
No, we will take it up. What are these cases? This
Only
is,
four NCC cases, only 4.
they are
five.
not on the list, right?
Today they are not on the list.
They are
They were
adjourned
adjourned
after
after
2
2 weeks. But because Lordship, they filed the writ petitions for
So, all right, so for vacation of stay on Monday. Vacation of stay, you examine. You can file thereafter, counter, no problem.
Get instructions.
You can get instructions and argue like
We are working, Delhi is working tomorrow. We are only not working.
this. That
Even
is a special day for this part of the country.
Even on holidays
Yes.
also I get instructions.
Huh? You can, yes.
Monday.
Monday. No, today we will see a lot of you, so many matters
Yes,
today.
yes, yes.
Mr. Rao, yes.
My lords, kind permission, my lords.
Ah.
My lords, yesterday, my lords, your lordship directed the university to declare results in respect of petitioners, my lords. In spite of the directions, my lord,
No, your item is,
my lords. Yesterday, my lords, your lordship.
Local, non-local matters.
Local, non-local.
So Lordship heard yesterday.
got 15% quota.
Yes.
My lords, we fall under the category of 85%, my lords. Because, my lords, our parents are not.
85% is being decided, right?
My lord, there is an interest.
Yesterday we have heard the arguments. It is not even 24 hours.
My lords,
We are also human beings. I mean,
my lords, one
and the things will not stop here. It will be carried forward. So we need some this thing. It's not even 24 hours and you expect judgment from us, right?
No, my lords, one
No, but the oral submissions will not help in a reserve matter.
no.
You want to file any application, do it. We will consider it.
My lords, my parents
Yes.
do not fall under the All India Services, my lords. My lord, this is a
No, your case is listed today.
no, my lord. But the difficulty is, my
No,
lord,
no. So what has been done to your case?
my lord, my parents do not
No,
follow.
no.
Yesterday,
Reserved, my lord.
Reserve. Then nothing.
There is an interim.
File an application in a reserve matter. This sort of a mentioning oral not permissible. Yes.
I may be permitted to move on lunch motion, my lord.
What lunch motion?
Petitioner before lordship is a medical student, my lord. She has applied for management quota, my lord. But due to oversight, my lord, she has not put tick to the.
Mr. Rao, see what management quota.
cut-off date is over.
Whatever, but it has to be listed at least. You please, Mr. Supply a copy to Mr. Rao first. Comply with office objections. It will come.
Because, my lord, if they will finalize, my lord, only.
What is the urgency?
Limited seats are there, my lord. She has already qualified in NATE, my lord. Only thing
So,
is that.
madam, we are taking up your case today. What else? You don't get it.
Okay.
We told you to supply a copy and to ensure that there are no office objections. It will come up today. That's what we told Mr. Rao.
Acknowledgement.
Unfortunate that you don't even understand what is being told in the court. Yes.
230, my lord.
Item number 22. For appellant.
This is the last one.
Huh?
Item number 22.
No, who is for respondent?
Respondent has already informed.
No, see, Mr. What has happened is that people have this out of turn adjournment. People have taken, other councils have later on objected. So it will be called. Don't worry. Yes.
With your permission, my lordship, writ PIL number 23 of 2020.
No urgency. What PIL?
My lordship, it was supposed to be listed yesterday, my lordship, but it was
Fixed date. Fixed date was given.
Yesterday.
Don't make Mr. If this submissions are found to be incorrect, we will issue you a notice for contempt.
Yes, my lordship.
Very often in mentioned matters, we have found that these all submissions are incorrect. You are an officer of the court. At all times, you have to behave reasonably with the court. There was a court given date.
Yes, my lordship. It's on 23. It is showing on official website also of our Telangana High Court.
23?
My lordship. It's 23. Yes.
Esther, we have told all the members of the Bar Association, you have come from moon, right? So therefore you don't know. You have just come from moon, right?
Yes.
We have landed there and you have come from moon to earth. So you don't know. We have said that there is this thing, auto date system, auto dating system has been introduced. The system generates a date which is tentative. That does not mean it's a court given date. Court given date is when we say list on Monday, then it is a court given date. If the system generates a date, it may be listed, may not be listed, right? But tentatively it will be listed. So that is the difference, and you are telling the system generated date to be this thing, and you would have received the notice for contempt and you would have apologized by saying that unconditional apology because I did not realize. So we are telling you beforehand.
Yes, my lordship. My lordship. At last occasion, it was said like after 2 weeks it will be posted. My lordship.
We have not given any date. It will come up, Mr. Public interest litigation, don't worry. We will appoint amicus and we will take care. What is it about? What is it about? We will tell you what is the outcome.
Illegal allocation of land without conducting any auction.
All
And my
right.
lordship.
So today only, Mr. Illegal allocation of land. Wait, you are not permitting us to pronounce judgment. You will be well advised to read one of the judgments of this court in a PIL about its maintainability and the second judgment today, which is being pronounced. Read it. It will tremendously benefit you,
Yes, my lordship.
right? First read it. Otherwise, we will call it today itself and dismiss your petition. Nothing will be served.
Yes, my lordship. But my
So
lordship.
you have been set up by the person who has not been given contract to fight it as a PIL. He is sponsoring the litigation. That's why you are mentioning, right? Correct. So go through the judgments. Scope of PIL. What is it we have dealt with in detail?
Yes, my
And right now we can tell you that you have not disclosed your antecedents in the writ petition. You have merely said, I am a public spirited individual and a social worker.
My lordship.
Prepare the case very well.
Yes, my lordship.
Go through this judgment. Read the judgment of Supreme Court 2020-23 SSC online page 5. Then argue.
Yes, my lordship.
PIL, lunch motion.
GOMS number 72, medical admissions.
We don't know 72.
GOMS number 72, medical admissions.
Which rule?
100% quota, my lord.
100% quota.
Yes.
30th after 2nd June 2014.
Yes, yes.
Say so, Mr. What is GOMS? I say GOS number 118. Will you get anything out of this?
100% reservations.
Say so.
Yes, sorry, madam.
What is happening in lunch motion? What happens if it comes on Monday? Tell us. Tell us what happens.
Yesterday it is.
It can come up on Monday also, right?
I leave it to you, last.
No. You tell us what happens, what irretrievable prejudice petitioner will suffer if it's not taken up today and taken up on Monday. Tell us. Mr. Rao also needs breathing time. No? We cannot force him every case. Monday.
So, my lord, sir, item number 100. I'm from
No adjournment. Out of turn is that this thing is.
Subject
It
to
will be called. When it is called, you mention. You are going home, right? 10:30, seeking adjournment.
Sorry, my lord.
Don't want to go home, right? Then wait.
Subject to
Yes.
permission, permitted to do lunch motion.
Huh?
Let the petition join with the dental
You
college.
want to withdraw?
No, Milan. Petition joined in medical admissions, Milan. Petition joined in the dental college. Now she wants to shift to the medical college. The certificates are original certificates in the dental college, Milan. The last date is 26th, Milan.
Not written. Sorry. Monday.
And last date is 26th, Milan. Day after tomorrow is the last date, Milan. So admission.
Where were you? People were mentioning
Yes, sir.
public interest litigation.
Hey, not public
This is really urgent. Yes, today.
Today.
Ah.
Sir,
comply with office objections.
Yes,
right? See to it.
Give a copy to
Yes.
Mr. Prabhakar Rao so that he will
Judgment.
get in.
Yes, Mr.
Yes.
Madam. Why? Judgment. Yes, Mr.
Namaskar, sir.
Namaskar.
My name is S.B. Ramesh, retired income tax commissioner. I am being subjected to harassment for the last 7.5 years. Despite Supreme Court of India and this High Court orders, contemners are continuing the contempt offense.
What is this noise, Mr. Registrar? See,
May I continue, sir?
No, ఇది తెలుసులేండి ఇన్కమ్ ట్యాక్స్ ఆఫీసర్ I myself dealt with.
no, and
Vital rights,
this
that's what
thing, veranda, something.
Veranda, there is some noise.
What's happening?
Why is he creating noise? Disturbing the court proceedings, he will
Take
unnecessarily attract
the
one more
whole,
case.
this thing, police security not there in the court. Keep everyone present here and take him away.
You can't create
Mr.
nuisance like this in the court.
Madam. Why police, Mr. One thing, Mr. Reddy? Why police? 1 minute, Madam. Police, I have not seen any police personnel in my court. He should be here sitting behind. Then he should
take care of. No, they should not.
take him out. If he is unable to handle, he call 3 or more his colleagues. This is interference in administration of justice. And Madam, one thing. One person in uniform should sit all the times in the court there at the last bench.
May I continue, sir?
No, your case is not pending before this court.
No, sir, it is not being pending, but I have, my submission is, sir,
You will meet Registrar Judicial, Mr. Reddy. You meet him, we have given it to you. This is criminal appeal.
okay. Thank you.
Huh? Tell him in your own way.
No,
Make a mention. The criminal appeal we don't hear, so we can't grant a court slip. Yes. Next. In view of preceding analysis, impugned order dated 28/4/2023 passed by learned single judge is set aside. However, it is clarified that this intra-court appeal is confined only to 53 acres of land bearing survey number 83 bar covered by 7 registered sale deed executed in favor of applicants. It is further clarified that land at measuring 470 acres in survey number 83 is in possession of the state government in view of statement made by learned advocate general in WP 30855 bar 2016. The respondents are restrained from dispossessing the applicants in respect of land measuring 53 acres in survey 83 bar 2. The respondents are also restrained from demolishing the fencing sheets and constructions raised by the appellants without taking recourse to law. It is clarified that the court has not expressed any opinion with regard to title in respect of subject land, and its same is kept open to be adjudicated in an appropriate proceeding before the competent. This was so except in accordance with law, it should be. PLM. Call PLM. The writ appeal is accordingly disposed of.
Right, obliged.
Next. One minute, this will correct this PLN to ask. No, this is correct. This he will take marks. No, this say that. Yes. In view of preceding analysis, we do not find any merit in this writ petition. The same fails and is hereby dismissed. However, respondents number 1 and 2 are directed to ensure that the payment is made to respondent number 3 as per terms and conditions of the contract. In the result, writ petition is dismissed. You have, madam, this judgment we have delivered, item 1. You have it available online? Or it will? Only PLN has access? Where is it? So only one, this thing I will tell you. You can type. This is. Here, correction. It is further clarified. And here, except in accordance with law. That's all. Get the page and so that we sign it. Yes.
May please, your lordship.
Yes. It's a tractor of the 2005, my lord.
Ah,
Tractor of the 2005. my lord.
so
Madam, only release
no,
of.
but the direction is to dispose of it, directed to verify. What is the order?
Your lordship.
Not directing release.
Yes. Page number 11, your lordship.
1 minute.
I'm sorry.
Just give it just now.
The respondents are direct, but the respondents are directed to verify the, not the ownership of the tractor and will decide as per the law.
Then you decide why writ appeal. Such officer, such terms and condition, everything you want our approval.
Appeal filed.
I filed the appeal.
Appeal filed by.
I
Nothing,
filed the appeal.
there's nothing wrong. Acha, we thought that you have filed an appeal yesterday, like
Your lordship.
saying that section, which section? 64?
59.
66, 59.
Regional.
We thought that this thing.
Your
So
lordship. The petitioner is not, the appellant neither the accused is not. They are
Nothing,
not
Mr.
issued.
There's
no-
nothing wrong with this order. In any case,
For they're not issued any notice, my lord, even for.
they will do it. How much time will you conclude the proceeding?
One submission,
3
my
weeks.
lord.
3 weeks.
3 weeks.
Your lordship, already 6 weeks,
3
this
weeks.
court direct, only interim custody, my lord, I'm asking.
6
for.
weeks was the time
Expired.
given. He is, see, this was June 2023, mister. He must be dependent on agriculture.
Yes,
He
sir.
needs his tractor.
Yes, my lord.
And he
Interim custody.
will again cut the trees belonging to forest
Miller.
department.
No, my lord.
So,
As
You will-
interim custody, my lord.
we found it very strange that I am the owner and I am the owner of the land and I am the owner of the tractor. Therefore, I will cut the trees belonging
No.
to forest department.
No.
This is the writ appeal.
No, my lord.
Ah.
My grievance.
No. Had it been filed by any corporate house, we would have dismissed it by cost of at least 2.5 lakhs.
My only.
Frivolous appeals.
Only grievance, interim custody of the release of the vehicle, my lord. Can't
Who will apply?
let them cascade.
Who will apply? Did you apply for interim custody? High Court will release on interim
Court
custody.
itself directed, your lordship. Even 6 weeks also, they are not taken any steps. my
File
lord.
contempt. If the order directions contained in the order passed by learned single judge is not
Bloody
complied
murder.
with, remedy is not to file an appeal, file contempt
In
petition.
other cases, Miller, this court passed, page number 29 onwards, Miller, this court granted relief, Miller, to the others,
No.
Miller, release of the
This
vehicle.
court is different, that court, the case is different.
No, Miller, same,
Forget
page number
about-
29 onwards, your lordship may see.
If it is found to be false, mister, we will impose cost of 2.5 lakhs, correct?
Page number 29. only after-
25 lakhs, 2.5 lakhs, we will impose. Now, what is the order against you? Which is the order which has been, what is the direction which is against you?
Page number
How
11.
are you aggrieved?
that
Please
only-
read para 5.
Yes,
And this all comes with a cost of 2.5 lakhs, mister, right?
sir, the petitioner is the Miller, she.
Then don't argue. You understand, right? The time of this court is important.
I leave
In
it
a
to your
frivolous case, you are trying to argue when there is no order against you.
lordship. My only grievance is the,
And then no, your grievance is that I should have been made president of India. What can we do?
I leave it to your lordship.
In this intra-court appeal, the appellant has assailed the validity of the order dated 22/6/2023 passed by the learned single judge, by which writ petition preferred by the appellant has been disposed of with the direction to the respondents to ascertain about the ownership of the tractor which was seized as the aforesaid vehicle was involved in commission of a forest offence. The respondents have been further directed to decide whether such tractor is required to be kept in the custody of forest officials, and in case the vehicle is not found liable to be kept idle and in the custody of forest official, it be released on such terms and conditions as may be appropriate. Paragraph. Learned counsel for the appellant submits that despite the expiry of 6 weeks till today, the issue with regard to custody has not been decided. In view of aforesaid submission, learned
GP for forest.
forest submits that the issue with regard to custody of the vehicle shall be decided within 1 week from today. Paragraph. Non-compliance of the directions of this court tantamounts to contempt of the court, for which we may have initiated the proceeding. However, in view of the statement made by so and so, we refrain from doing so. Needless to state that the application seeking custody of the tractor shall be decided by the competent authority by a speaking order within a period of 1 week from today. Accordingly, appeal is disposed of.
bless.
I need to read it again. No, I need to read it again. This seems. No, because how it has come up further. There may be something, right? Acha, at least we will sign and make it available. So that sign, no? Show me now at 1:30. 1:30 you come with this. Keep with that. Show it to the advocates. Show the advocate. You can show it to advocates and then get me in the afternoon. But let it be available. Yes.
These elections.
So you file an application seeking
I did my lord.
impleadment and vacation of
That's
stay.
true.
We will
I-
request the learned single judge to decide it.
But within some time, my lord. Some time, because
Yeah.
we have.
You have filed
Yes, we have.
When?
Government has also filed vacancy.
When? Impleadment. When have you filed?
Implead petition we have filed on 23/7
Ah.
and they have filed counter on 10/8. Government has
23,
also
7/23 and a vacate petition
vacant petition also on the same day. Here we filed both petitions
and
simultaneously.
government
Government has filed its
2nd August we have
petition.
We already had filed vacate petition.
when
2nd August 2000.
all this intra-court appeal has been filed against an ad interim order dated ad interim order dated 19/7/2020-23 passed by the learned single judge, by which learned single judge has directed the interim stay as prayed for by the petitioners. Paragraph. Petitioner stroke respondent number one in this appeal, right? You are respondent number one in
Yes,
this
wait,
appeal.
wait.
Paragraph. Learned senior counsel for the appellant submits that the appellants are necessary parties to the list. However, without impleading the appellants, comma, the respondent number one has filed the writ petition. It is fairly submitted by learned senior counsel for the appellants that the appellants have filed an incomplete petition as well as a vacate petition on 23/7/2023. Full stop. The government advocate also submits whatever GP revenue.
Just keep it for Panchayat Raj.
Panchayat submits that that state government has also filed a vacate petition on 2/8/2023. Full stop. It is stated by learned counsel for the appellant and so and learned senior counsel for respondent number one. It is stated by learned counsels, you say. Learned counsels appearing before us that aforesaid applications are pending. Correct?
May say.
Full stop.
On 18th, my lord, they were listed and mention was made, and it was adjourned to 11th September because additional advocate general said there is a batch of writ petitions pending. It is a policy matter. On 18th, my lord, they are listed at serial number 75. I made a mention at 2:30. Nobody was present for the appellants. Then finding all for the record, my lord. Then nobody was present for the applicant and vacate petition. That's how it's adjourned to 11th September. The request of additional advocate.
Your lordship sees, my lord, we made a mention before line.
No, is it correct?
No, that's what I'm come.
All right.
The learned single judge.
In view of aforesaid submission, comma, learned counsel for the party shall be at liberty to prosecute their application for to press for the application for impleadment as well as application seeking vacation of stay. Needless to we request the learned single judge to take up the vacate petition as well as application for impleadment expeditiously. Accordingly, the appeal is disposed of.
My lord, within some time at least, my lord.
No.
See, ex parte order is
Please
granted.
be on the guard now. Sit there. We are not going into what he said. That otherwise, it's said.
But just only 1 second, my lord. What the learned single judge told me was, you go and get.
We don't know.
Very well. I'm sorry.
We have said like this is. You will appreciate that it's not a this thing. The court subordinate to this. We are only. It's a matter of combination.
Very well, my lord.
We cannot. That's why we cannot issue a direction. We have requested him to deal expeditiously. It is all taken very well. You say that, like to say that he is directed to decide it
No,
by
I'm saying
tomorrow
directed. I was only saying that.
by a particular time limit. That's not done.
Very well.
You understand?
No,
Senior counsel.
No, because
Everybody is not requesting the High Court.
Even Supreme Court doesn't direct us.
No, may I enter a small caveat here? Only 1 second. My lord, the Honorable Court is requesting the senior single judges to hear the matter expeditiously, but the registry is not.
Decide the application expeditiously.
That's what may
Produce the copy of order and
Right, may I make
make a mention, ma'am.
May I make a small suggestion? My lord, in matters where such requests are made, let the registry have a red sort of a docket so that those cases are posted. My lord, even the registry people know that there is some.
Yes.
Lordship is saying is, take our order copy, make a mention before the learned single
Very well.
judge.
That
with
the
copy.
division bench is requested.
So once
Division bench is
the
requested.
court gives a slip, it's a judicial order, that registry has no role to play in listing the matter on that.
Very well, I appreciate.
Those are the
but
instructions given. Yes.
Fine.
Lordship's permission, I am permitted to withdraw the petition, the liberty to agitate before the collector.
Before
Collector.
learned counsel for the appellant seeks leave of this court to withdraw the appeal with the liberty to agitate the matter before
Respondent number 4.
respondent number 4, namely so and so. The writ appeal is dismissed as withdrawn with liberty as aforesaid. Pending IAs are disposed of. Yes.
It's part of marriage. So challenging malad, MBBS counseling malad,
Ah.
it's 100% quota malad.
Ah, what happened? The notice has been issued first time.
First time they are coming, Lord.
Last time, Mr. Rao
I will take notice.
heard on the question of admission. Some case we have passed an order, no? Mr.
At the Lordship was pleased to pass an order. At the time, we were rep counseling was
No,
going
which
on.
case?
Blood, the item number
You so that, I mean, it will be easy, no, because this order will be different. We want to write something.
Yes, sir.
We have referred, that's why we understand that that was first round of counseling.
Yes, sir. That
Which
is item
item?
number 26.
26, madam, give file.
Except 14.
Heard on the question of admission, item number
Blood, I want to make.
6. 1 minute. Yes, yes, Mr. Rao.
Blood, my submission.
So we only want to state what is the challenge like, so that when it comes up, we know that what is it. So what do you want to say?
Blood, my
You
submission.
want what interim relief you want, Mr. Counsel?
Malad, it's a page number malad, earlier order passed this panel court malad, page 90 malad I filed. Malad, sir.
90.
90 malad.
Ritu, that's what we are searching
Sorry.
for. You should
Sorry.
have told that, sir.
Sorry, malad.
We have filed it at page
Yes.
90.
90, yes, malad.
Yes. Yes. We have got it, madam. This is WP 18047.
7 malad.
Colleges and 39.
Hmm. So 20 colleges you will consider is entitlement.
yes, sir.
Same order, right?
Yes, yes, Lord.
All right. Same order, madam, right? Page 99. Heard on the question of admission. Petitioner is a student who has one only or several.
Sir,
Only one malad.
One petitioner
Only one
is a
malad.
student who has completed 10+2 course and has appeared for NEET undergraduate examination 2023. The petitioner has impugned the validity of Rule 3 within bracket capital Roman 2 bracket close within bracket small h of Telangana medical and dental colleges admissions within bracket admission into MBBS and BDS courses rules 2017, which is quoted below. Quote this to here. This quote. Learned counsel for the petitioner submits that the writ petition involving similar issue has been entertained and an ad interim order has been granted.
Sir, in this malad, in the order.
Ad interim order has been granted in support of aforesaid submission. Reference has been made. When the order is being dictated, don't listen to advice of others. He can't do anything.
Sir.
Reference has been made to order dated 19th August 2023, passed in WP number 18047, bar 2023 and other connected matters. In view of aforesaid submission and for the reasons assigned in the order, it is directed that the candidature of the petitioner in respect of seats in 20 medical colleges, 20 medical colleges 4th September.
But further direction in the order, my lord,
No, no.
34 college.
So this is all prompting, right?
No, my lord, it's order.
Prompting by your friend.
No.
Don't Mr. disturb the proceeding of the court. We watch everything from here.
Correct.
You argue your own cases when it is fault. Or you argue his case also, then we will hear about.
In the order, my
What
lord,
further direction? This is the direction passed in similar case. We cannot depart like case wise because you are appearing there for different order. The court has to be consistent. What further direction you want?
my lord, to director, my lord, in the result, my lord, university shall take action, consider petition against, my lord, in other 34 colleges, my lord.
Sir, but they are not entitled.
That is,
But they are not entitled.
Mr. This is the interim order. That will be what is going to be adjudicated in your rate
No, my
petition.
lord, but
That's why 4th September. Let him file counter.
That's why we fight count.
Then mark their presence, Mr. Prabhakar Rao, Learned Counsel. In the beginning, accepts notice on behalf of respondents and praise fund is granted. A week's time to enable him to file counter.
2 weeks. Anyway, a week,
2 weeks.
not week, week time is up.
4th September.
Yes, yes, yes. We want.
Week's time to enable him to file counter. Then petitioner is a student and all that interim order list on 4th of September 23. Get us a copy of this order.
That's my posted at 6th, Willard, 6th. 6th.
35. This is updated, no matter.
As of yesterday, updated.
All right, 6th September.
but next matter is also, my lord, same,
One-
similar.
So 7th is same.
Yes, my lord, same, my lord.
All right.
8 is same, Lord. 8 also same.
8 same.
8 is, my lord.
8. Who appears for it?
I am appealing for the 8. Similar matter. 10, 17.
6, 7, 8, 8, 9,
9,
10,
10 same.
12,
10, 12, madam. 12,
13,
13,
14.
11 is not. 11 is not covered.
No, no.
14,
14, 17,
17,
18,
18,
19,
Lordships.
19,
21.
21.
Your
Same
Lordship.
order, Mr. Rao.
Yes, Lordship.
Your Lordship, item 13 also same.
1 minute.
1-3 Miller.
14.
Huh?
13, 14.
Item 13, 14.
14 is also same matter.
Same matter.
14 is different matter. 14 is different matter.
NRI.
14. Then
13,
delete 14 from that list, right?
13 also same.
So
Same.
14 delete and rest whatever we have put.
And
See,
15
again we are repeating 1 minute. Item number 6, please, item number 6, this order which we have just now passed, same order is passed in 7, 8, 9, 10, then 12, 13, then 17, 18, 19, 21. 16 also, Mr. Rao.
That's 15 is different, Lord. 16,
Same.
16 is same, Lord. 16 same.
16 also same. Right.
Lord, 18 same, Lordships. 18 same, 19 same.
18, 19 and 21.
21. Yes.
Correct. 14 is different, 15 is different. 11 is different. Right? So same order list along with that case, all matters. Yes. Then item number, all madam.
Please, Your Lordship. I beg to appear, Your Lordship. So the matter pertaining to applying of cap quota for CRPF and BSF, Your Lordship, wherein Your Lordships have decided.
We have decided. Give to copy.
Your Lordship already have filed a writ petition with regard to that, Your Lordship, which you have
Under Article 32.
which Your Lordships have dismissed my writ petition, Your
Ah.
Lordship. Challenging the reservation, I have
You have filed the SLP.
No, Your Lordship. Challenging the reservation, I have filed the present writ petition, Your Lordship, wherein the impugned reservation is at page number 13, Your Lordship. Your Lordship may kindly peruse it, Your Lordship. Your Lordship, they are applying a
Heard on the question of admission, petition is admitted for hearing, issue notice.
Your Lordship, may I submit humbly one thing? Your
No, it's not that we dismiss, so again challenge and vision and then say interim order. We cannot grant interim order
One
contrary
thing,
to
if Your
the-
Lordships are pleased, Your Lordship.
any admission made shall be subject to result of the writ petition. Madam, right heard on the question of interim relief, it is directed that any admission made under cap was children for armed food personnel shall be subject to outcome of this writ petition.
Obliged, your Lordship.
Mr. Rao,
Yes, Lordship.
praise warrant is granted, accepts notice, whosoever these people accept notice and pray warrant are granted,
For filing counter, 2 weeks.
3 weeks time to enable them to file count.
One thing is
Any
that,
admission made.
Your Lordship, I know I am troubling your Lordship. One thing I would like to bring to your Lordship's kind notice. Lordship, and last year they have considered the
That
applications
was a
of.
concession, Mr. Kiran, that was a concession made by Mr. Prabhakar Rao this year, Mr. Sanjeev Kumar, in fact, if I recollect correctly. This year, they are not willing to make a concession. That is the end of the matter. So validity of the otherwise needs to be tested.
I leave it to your Lordship. I just want to bring.
There is no question of
Challenge
leaving.
without counter cannot be.
You are holding us accountable for concession given by the council. We can't make them, we cannot force them to.
My submission is
One
that-
minute. We cannot force him to make a concession. No, supposing if you are appearing for some respondent and you are not willing to give concession even though you had given last year, can we force you?
I completely,
No.
I completely accept your Lordship's.
Answer is no, right?
Yes, Your Lordship.
Ask Mr. Prabhakar Rao. He is all powerful man, Mister. He can admit, notwithstanding this, you are this thing, instead of filing counter, he can say petitioner has been admitted and the petition has been rendered. He is all powerful man.
Anyhow, subject
We
to.
can't do, we are bound by law. Four corners of law.
Obliged, Your Lordship. Deep, Your Lordship.
Yes.
Lordship, the petitioner applied for the B category management quota seats, but could not
Ah.
tick the NRI quota.
Ah.
By mistake, she could not tick the NRI quota. She made a representation on the
That's why I direct them to consider and dispose of the representation.
representation committee number 74.
74.
In fact,
In
Lordship,
this-
kindly see, management quota well, is consists
So
of.
you consider is a representation. We are not saying anything, right? In this petition, comma, petitioner inter alia seeks a direction to KNR University Health Sciences Warangal to consider the representation, consider the case of the petitioner for counseling. Said that we will, all right, we will consider his representation. He has got the hint. That's why he said that, yes, I will go there
May I please?
15.
Matter pertaining to MBBS seat Millard, non-local and local birth is Millard.
Non-local and local.
Matter, page number Millard.
You are a local candidate, right?
Yes, 1 to 10 studied in Hyderabad.
1 to 10 Hyderabad.
Intermediate studied at Rajasthan.
Same matter yesterday also was
Heard reserved. Heard reserved. This thing, add this also, WP number, so add whatever facts, 1 to 10 Hyderabad, then plus 2 Rajasthan, whatever and whatever. Submission, his submission of adopt submissions of senior counsel in Mr. Reddy and Mayur Reddy. That one paragraph. All.
My lordship. Lord, the petitions filed my lord for admission to MBBS my lord. Where my lord, the petitioner placed under the ineligibility candidate on the ground that my lord, she has not produced a residency certificate for the 10 years. My lord, she is claimed as a non-local.
Same, right? Your local candidate.
Non-local candidate.
You are non-local.
Yes, my lord. As per the my lord, GO.
They are treating you as local.
No. What they are doing, my lord, they have to, for category, competent authority category, my lord, they have to produce the 10 years staying in.
1 minute. Mr. Rao, this is something different than the one we have been dealing with. Huh? But he's saying non-local, I am non-local.
But on the ground that, my lord, they are
1 minute.
obliged.
Because see, we have been hearing Mr. Rao and other counsels for 2 days. That's why we have asked him whether it is a case covered with that category or different. Then he says different, then we will hear you, of course.
parent certificates have not been enclosed, my lord.
No, what is his claim?
But he has not enclosed, my lord, study certificates where he has studied.
No, what is his claim in the petition? He wants to be treated as local candidate.
Local candidate.
Under which rule?
No, my lord. There's a case before the petitioner is, my lord. My lord, she is claiming as a non-local. Category A, my lord, competent authority quota, my lord, they have to produce under 114 of the GO of 2017, my lord. The parents' residence of 10 years has to be produced.
Not that, sir.
That was not produced because, my lord, MRO was not given. On eligibility, my lord, they put it in the ineligibility candidates. And they given a time for 29/7/2023. On 27/7/2023, my lord, the father of the petitioner submitted the residency certificate, my lord, page 8, my lord, of 3536 for 10 years.
Well, Lordship, kindly see the petitioner is claiming as non-local status. Under class, there are even,
She is claiming as non-local status
Non-local
and she has been held to be ineligible by you.
even non-local also, the
Ineligible.
eligible.
That is under challenge.
Yes, sir.
So this is something new.
Yes.
Yeah. So let him seek instructions.
My lord, I filed, my lord, certificate, my lord, 1 minute, my lord.
No, we are issuing notice to him. He has to be heard, right?
Lord, I filed a certificate according to their.
No, so it should be allowed today and result declared and MBBS certificate granted to you, which is to be granted after 5 years.
Lordship, put it on Monday, I will update you, sir.
Tuesday. Tuesday.
But he needs some time to respond. This is not a controversy covered by cases which we have heard so far. It needs consideration, therefore he needs to respond. Mark this, in this writ petition, commonly petitioner inter alia has heard on the question of admission. In this writ petition, the petitioner inter alia has prayed for a direction to respondents number 2 and 3 to place her to treat her as non-local candidate and
The parents also. I'm saying that I'm a non-local, please consider me as a non-local. Because all my childhood onward schooling, everything is in
Because
Maharashtra.
he did not enclose bloodshed.
No, why is it required? First of all, I'm myself saying I do not belong to this state.
Yes.
A condition which doesn't make any sense. You see, somebody asking for.
You can, so therefore, brother is saying that you seek instructions in this light and say that we will treat her or him
Yes,
as
yes.
non-local whatever.
Lakshmi put it the Monday, Monday,
Tuesday, we said, no?
Tuesday.
Acha, Monday, Mr. You wanted on Tuesday, he wants it on Monday, so we will fix, go by his
Monday.
convenience, instead of Tuesday, Monday.
Okay. The batch cases, blood item 25.
No, no, 22. 22 is different, Mr.
This matter below, this morning I requested time.
You were mentioning in the morning, we assured you that it will reach. Yes.
That's it.
I'm appearing for response 1 to 6, my lord. My learned friend wanted time in this matter. Learned friend wanted time in the matter.
No, this is why he is seeking time, because the interim order has been granted.
It's a.
Interim order has been granted on 25/6/2008. Therefore, he is seeking time. The moment we will vacate the order, say that it will not continue, he will be ready.
In fact,
No.
policy has
State-
framed.
Oh,
Representing state.
you are representing state,
It's not about.
Huh?
I'm representing the appellant.
appellant, state.
Yes.
That's why. Correct?
Well,
There is a stay in your favor.
No, 1 week time may be granted.
No, Mr. Why 3823, Mr. G. Narendra Reddy, appellant, place for adjournment 24/8.
This is a,
Again-
actually, I thought that it's a infectious, my lord. The policy, this is a,
Say so.
no, that.
And make an application for revival if it has not become infructuous.
This matter, my lord, I think the board, they want to engage the advocate general, my lord. That is the reason I want time.
Learned counsel for the appellant submits that the matter has to be argued by learned advocate general. By way of indulgence, hearing is deferred. No, we will admit this, right? Or what, by way of indulgence, hearing is deferred, list after 2 weeks.
Please, Lord.
Yeah.
The petition is listed under the caption for orders of the court, my lord. The writ petition is listed under the caption for orders of the court. This is a PIL which is filed challenging a GO which seeks to regularize sale deeds or transfer documents which were previously only signed on notarized.
Mr. Wow, we have delivered one judgment, this bench.
Become two.
Item, no, not this, madam, the other one, PLN knows. Ask PLN. We have written everything about public interest litigation. And Mr. We had told you to keep it here. Public interest litigation. So, Mr. Whether you, just a minute.
Yes, sir.
Whether a petition contains an averment that the persons aggrieved by this GOMS are so poor and illiterate that they are not in a position to approach the court, and therefore you are espousing their cause.
This is in fact the other.
No, Mr. That either you are an aggrieved person, things then are different. You are entitled in your own right to challenge these guidelines.
Yes.
But you are filed it as public interest litigation. Public interest litigation, we have held by a detailed order. Please have it. Read it before arguing the case. That we have traced down the entire law from, I think, past about 30 years on PIL, and eventually the law laid down in Balwant Singh Chaufal, if you have read it, which is the judgment of.
I'll take it.
No, which is the judgment? Balwant Singh Chaufal is a law laid down by Honorable Supreme Court. You don't have a copy, madam? Don't have a copy? No, not PIL. Whole this thing PIL. Get a printout, madam. This is today's judgment. This is not required. So principles laid down in Balwant Singh Chaufal have been approved till recently. So therefore, the writ petition must cover, contain an averment that the persons agreed by GOMS dated, listen to us,
Yes, but
GOMS dated 26/7/2023 are so poor and illiterate that they don't have means to approach this court, and therefore the writ petition is being filed on their behalf challenging. In the absence of such an averment, we will dismiss the petition.
yes, my lord.
You file it as a writ petition, understandable. But this public interest litigation business has to stop. Who are you?
Submit.
No, you are Citizen Welfare Association.
Yes.
Another interesting thing is, you have said objective of first petitioner is to work for welfare of all living beings on earth. All living beings,
Protect and safeguard.
including GP for revenue also. So he is asking what have you done for him, welfare of Mr. GP for revenue? All living beings.
Yes,
So a person from Namibia may ask you, what have you done? He is suffering from South African countries, suffering from hunger. So what steps have you taken? Poverty, this thing, eradication, hunger management. What have you done? Please tell us.
Yes, my lord.
So therefore we dismiss it.
If I may only submit, the petitioner before your lordship
Nothing.
or any of the persons who
Mr. You will get, if you have not read the order, you read your own order if you time permits.
lordship may take it up
If
on
time permits, we will, no. This all,
no,
Mr.
lordship will see the
Monday, 30th August, we are awfully busy every day. We are this thing, not this thing that it is listed. I will see.
no, my lord.
Then Monday, then you will say Monday I will come at 4 o'clock. So take at 4 o'clock. We don't need you, right? This
No, no.
is
Only-
public interest litigation. We are dismissing it.
Yes.
This is the judgment.
Well,
We are,
my
you have not read it, Mr. Thank you.
Well, my humble submission is, my lord, that the PIL
No.
is seeking to protect the rights of the people.
No, we are asking you antecedents. What have you done for welfare of all living beings on earth? What have you done
No, in
for
fact, there's-
hunger eradication of persons in South, in South African countries? Several countries have malaria problem. What have you done for all living being planets? What have you done?
Same
Please.
petitioner had previously filed another
No.
PIL, my lord, before your
Filing
lordship.
PIL doesn't mean.
But for
This is what
protection of
happens.
111.
No, the rule requires
It's on the court that
rule requires you to give antecedents of public. The antecedents of public activity is not filing a writ petition in the High Court. You understand, right? What query we are putting, you understand.
Yes, ma'am.
You understand.
But
Better withdraw.
only submission is, my lord,
Nothing.
by way of this government order,
Hmm.
which is absolutely lacking in legislative
No,
competence.
several things are lacking in legislative competence. That doesn't mean that anybody should come.
It is,
Aggrieved persons are well within their rights to challenge it. Any person, we are sure.
because he is not an aggrieved person, my lord. As of today,
Nobody is aggrieved. How are you
the
aggrieved? then?
petitioner before your lordship is more
No,
on the-
petitioner is not an aggrieved person. Mister, you understand. You are not that dumb. You understand that we are trying to tell you that persons aggrieved by this government order are in a position to approach this court and challenge and take recourse to the remedy available to you. This is not a cause. They are neither bonded laborers nor persons in detention. They have not been anybody, aggrieved persons have not been detained by police authorities so that they are unable to approach anyone, and therefore you learned by visiting the police station that they need help. And they told you that please challenge GO on our behalf. Nothing.
Yes. Those, my lord, in fact, the time window for this under this GO is 3 months. Within 3 months, my lord, the objective of the GO is to reduce.
Mister, we are all this is you are shifting to this thing merits. We said that you may be aggrieved, you may challenge this GO. Anybody on earth can challenge this GO, whosoever is aggrieved, right? But you don't have a locus in public interest litigation. That is the simple thing.
The loss to the state, my lord.
Fine.
My arguments which are made is that this GO leads to a loss to the treasury.
The stand registered document by regular entity. So make the affidavit. They are seeking to regulate.
Yeah, but you, I mean,
They are seeking to regularize the unregistered documents.
you should we can permit us. You convert this public interest litigation into WP.
Petition.
We will challenge, we will entertain. We quite see the object.
Obliged.
The only this thing is with regard to PIL.
Obliged. We'll.
And this is what we have written. You, all of you should better go through this.
Yes, we'll.
And before arguing and just walking in.
We'll do that. We'll
You know, we are sure that you know what is Balwant Singh Chofal, I am sure.
Yeah.
We know that you know what is Anil Agrawal Foundation.
Permit me to convert it to WP.
No, why? They can challenge. That's fair. You have a locus to challenge this, right? You are a taxpayer. Any taxpayer can challenge.
I'm grateful to my lords. Permit me to grant me liberty, my lord, to
Yes,
convert it.
you amend the petition, that's it. After arguing we are not saying anything else. After arguing the matter to some extent, learned counsel for the petitioner pays for short accommodation to enable him to amend the writ petition.
Obliged.
List on, when do you want?
Your lordship.
Tuesday, Wednesday,
Tuesday, my lord.
Tuesday.
Obliged.
Amend the petition.
Grateful.
So not Tuesday, Mr. 30th August.
Right.
30th August. Please go through this judgment, right?
29108, WPSR number
29.
108 of 2023.
It must be available, right? We have signed it on the website, no? Judgments.
May I please?
Yes.
This is pertaining to the protection of the public property, that is Sardar Vallabhbhai Patel Satram, which is
So who is making construction on it's a
That is,
public property, right? As we understand, 1 minute, as we understand, your case is grievances on a public property, somebody is raising construction unauthorizedly. Who is raising construction?
that is the eighth respondent, Billard. And the municipality also is that
Did you, 1 minute, did you make any complaint?
yes, ma'am.
Where is it?
It is right. This page number for collector on 19/12/22 and
Page
municipal
82.
commissioner 6/3/2023.
Page 82.
Page number 85, page number 82,
82.
and as well as to the municipality 85.
Who is there for the council? Who appears?
I'm appearing for response 5, 6, 7 and 9.
Your municipality, right?
No, I'm sorry, I'm for the endowments.
No.
Concerned municipality.
Municipality 3. Right, not conveniently not saying anything. The entire this thing is grievances about you not doing anything. You tell us why we should not impose costs on you. Say about 1 crore for not taking action on the complaint. What have you done? This petitioner made a complaint to you about illegal construction. 1 minute. He made a complaint to you on the month of December 2022. 8 months have passed. What, your officers are sleeping? Huh? No, what? Like the famous character in this thing, Mahabharat, 6 months sleeping, 6 months awake. So from January to June, supposing if you have slept, then 1st July you should wake up. From 1st July till today, what have you not? Why have you not done anything?
I get the instructions.
Learned counsel for respondent number 3. Mr. So and so, learned counsel for respondent number 3. Now, what is this thing? Office objection about your this thing, Mr. Gandhi. It's on office objection. We forgot. So, rejected saying there is no public land. Public land. That's his case.
This land belongs to whom?
This is belong to
Belong to the
the
petitioner.
land purchased by with the donations of the Chegichal town people. I have filed to that extent of
A public property.
public property. I have filed the necessary all the documents. That is, and also is endowed.
And no, and the persons who had purchased this property, they are sitting silent. Their property is being encroached and this thing, and not doing anything.
Because time to time, the whistleblowers and others and in the journal, in the papers also, it is reflecting time to time, Milad. And nothing is going to be taken action, any action is to be not taken.
No, but it belongs to whom?
This is a public property, Milad. I have filed the necessary documents.
Where is that document to show it's a
Yes.
public property?
Yeah, that is-
Public means
Yes, Milad.
everything is public, right?
Yes, Milad.
Then which law?
Filed the endowment, endowed registered document.
Page.
That is page number 28. Translation is from page number 44, Milad.
44.
Yes, Milad.
Take the representations 1310.
And the relevant is there. May I read page number 45, Milad? May I read?
This is a property belonging to endowment.
Yes, Milad. It is endowed with the endowment department and appointed the executive officer, manage this property. Subsequently, what?
So this is belongs to whom? It is given on Satwan before the full trade.
That is Sardar Satram.
Sardar Vallabhai Patel Satram, which was named when the Sardar Vallabhai Patel was visited to the Hyderabad state with the armed forces, Milad.
Do you know what did you say? Sardar Sarovar. Sardar Sarovar is somewhere else.
Yes, sorry.
You have been recently been there, Sardar Sarovar.
No, but is it a public property or not? It's a public property.
Endowment.
Then
Endowment.
how is somebody demolished it and constructing?
Learned,
There were shops and other things without permission.
I have a submission.
learned counsel for the PT. Yes?
May take your lordship to page 69.
No, you are not arguing on merits. We are asking the municipal corporation which has woken up on 1st July, what they have done.
My only submission is, the subject institution is exempted as per the GOMS number 303.
No. So anybody can encroach.
That was also cancelled.
1 minute, one. What is, geo cancelled means what? That anybody can encroach. His grievance is, Mr. What have you understood if you have gone through his petition? What is his grievance?
It's a public property. It's on the-
No, grievance is that it's a public property. Somebody has encroached it and raising construction without obtaining permission.
Yes.
We are asking the municipality to find out
Deeply.
what objection can you have? Who are you? Who are you?
The submission was that, my lords, it was exempted from the provisions of the Endowments Act, my lords. That was the only
Then,
before your launch.
no, exempted, so what?
Will it change the nature or character of the property being a public property? The answer
It's a
is no.
public property, no.
It's a public property. That is why we are asking municipality how they have demolished, allowed the demolition, and somebody is constructing.
No, and at least, I mean, when petitioner had approached, they should have done something, right?
Yes.
They should have said that no action is required, it is being done in accordance with law, whatever we have examined. They are a statutory body constituted for public, but they behave as, they have an inherently anti-people attitude, these people. Even council is such like invitation, he stands up, he is standing up, not saying anything. GP Revenue is saying that he is for municipality. They need an introduction to the court as well. What can you, we have to find out at least.
The representation.
6th December. Learned counsel for the petitioner submits that the grievance of the petitioner in this public interest litigation is that a public property is being encroached, has been encroached by respondent number 8, and the construction on the aforesaid public property is being made without obtaining any permission. It is also submitted that the petitioner had submitted representations on
Collector to
to the collector on 19/12/2022
Municipal Commissioner on 6/3.
and to the commissioner of Jagtial municipality on 6/3/2023. However, the aforesaid representations have failed to evoke any response. Paragraph. In view of aforesaid, office is directed to register the petition as PIL. Learned Mr. Name. Your Jagan Madhav. Mr. Jagan Madhav, learned counsel for respondent number 3, shall seek instructions with regard to grievance of the petitioner and shall apprise this court as to what steps have been taken by it in pursuance of the representation submitted by the petitioner to it on 6th March 23. It is open for other respondents so these people accept notice. It is open for them to file counter if it is open for respondents to file counter if so advised.
These matters may,
1 minute, don't start arguing afresh.
these are all the same matters directed, posted on 6th September.
6 September.
Yes, sir.
Which case?
25 to 49.
25 give some fresh matters. So will you tell us where the cases in which interim orders have already been passed, or we will have to ourselves examine?
I will make my submission on that point, Your Lordship. My only submission, Your Lordship.
So you will not cooperate.
Mr. Rao. Item 26, 28. Item 26.
1 minute. We have understood your attitude, right? That you will not cooperate with the court. Fine.
I will answer the question and then if I may be permitted, I'll make a small submission, Your Lordship.
Mr. Rao, item number 25 is a fresh matter.
Yes, Your Lordship.
Nobody is asking you.
Same matter,
No, matter. It's a fresh matter.
A fresh matter.
So against this thing, educational institution established prior to 2/6/2014, you will consider this case.
Same order.
And you will, it has been posted on
6th September.
6th September. Yes.
Your Lordships, I have.
We cannot pass different orders in different cases. Item number 6, we have passed in order.
I have sought for another interim order direction, Your Lordships, with respect to the, on page 31, Your Lordships. The second interim direction petition that I have filed, Your Lordships, is for publication, when they propose to go for the second counseling, Your Lordships,
they will
Second
have
counseling date has not been notified.
your lordships. Yes, your lordships. However, when they propose to go for the second counseling, your lordships, they have to publish the
When-
seat matrix.
When they will go, do you think that Mr. Prabhakar will do it without publishing seat matrix?
Yes, your lordship.
This, if you are dealing with these matters, you should know that this is elementary, that they have to publish the seat matrix.
Yes, your lordship.
And then only they can fill up. No direction of this court is necessary
Your lordship.
at this point of time.
In the
When,
seat matrix.
1 minute, when the second round of counseling has not been notified.
Your lordship.
Madam, item number 6, we passed an order, right? Get a copy if you have. Yes,
Lordships.
666. Today we passed no, some. Typing 6, item number 6. Yes. So addition prayer is,
While publishing the seat matrix.
no, we have understood. This is the prayer.
I'm seeking that the local and unreserved may be specified in that, your lordships. On the last occasion, your lordships, the software problem was the one which could not protect the interest of the petitioners. To avoid such a situation, your lordships, if the seat matrix accommodates local and unreserved category, then that may be during the subsistence of this writ petition, your lordships.
We'll consider this prayer. We have understood. This is the prayer you want. Second round of counseling not notified, Mr. Rao.
But in fact, but they petitioned all the.
This prayer, consideration was not arranged because second round of counseling, it was kept open, and then it was notified. Second one, they out to the computer. So, Mr. We have understood. So, which are the fresh matters? At least if you can be kind and tell us what are the fresh matters or in which orders are required to be passed. If you can tell us serial number.
Excluding 26 to 30, your lordships, all the rest are fresh, your lordships.
26 to
30.
all fresh matters up to 49.
Yes, your lordships.
Madam, you write.
31 is old matter. 31 is the old matter,
Old,
not fresh matter. 31 is old matter.
31 also.
Yes.
Madam, see 31, any order has been passed?
Yes.
Or a fresh matter? So you write down, madam. 20, these orders will be passed in, we are passing an order just now. What similar order which we passed in item number 6.
Yes.
And this prayer is premature because it is kept open because the second round of counseling has not been notified.
One more submission, lordships.
We will keep this prayer open, not adjudicate it today because round is second. This is the order we have typed.
31 similar order earlier passed. Matter, old batch.
Mr. What's your name?
Anup Kaushik Karo.
Mr. Anup Kaushik, learned counsel for the petitioner. Heard on the question of admission, issue notice. Mr. N. Praveen Kumar, learned government pleader for Health, Medical and Family Welfare Department accepts notice on behalf of respondent number 1. Mr. A. Prabhakar Rao, learned standing counsel for Kaloji. All this here, madam. Accepts notice on behalf of 2 and 3. The petitioner is a student. Paragraph. The petitioner is a student who has completed 10+2 course and has appeared in NEET UG examination. The petitioner in this writ petition has impugned the validity of Rule 3 within bracket Roman capital 2 within bracket small h of Telangana Medical and Dental Colleges admissions within bracket admission into MBBS and BDS courses bracket close rules 2017 which is quoted below. Then this rule. Learned counsel for the petitioner submits that a writ petition involving similar issue has been entertained and an ad interim order has been granted in support of aforesaid submission, reliance has been placed on an order dated 9/8/2023 passed in WP number 18047 bar 2023 and other connected matters. Paragraph. It is also submitted that university be directed to publish the seat matrix providing for both local and unreserved candidates for second round counseling for academic year 23-24 of NEET for admission to MBBS courses. Full stop. Learned counsel for the university paragraph. Learned counsel for the university submits that that the dates for second round of counseling have not been notified. Full stop. Paragraph in view of aforesaid submission with comma as well as with a view to maintain parity. And for the reasons assigned in the order dated 19/8/2023 passed in WP number 18047 bar 2023 and other connected matters, it is directed that candidature of the petitioner in respect of seats in 20 medical colleges established prior to 2/6/2014 shall be considered, and in case he is found eligible for admission, an affidavit shall be filed or a submission shall be made on behalf of the university. In this regard, full stop. So far as the prayer made by the petitioner for publishing the seat matrix for both local and unreserved candidates for second round of counseling is concerned, comma, the aforesaid relief at this stage is premature as the second round of counseling, as the dates for a second round of counseling are yet to be notified. The petitioner is granted the liberty to mention the matter as and when the dates for second round of counseling are notified. List along with WP number 6, no, WP number 69, WP number
How much?
1 minute. They are also standing.
Well, as I passed on the slip.
1 second,
Thanking
just
Mr.
1 second, please.
Very.
Should send Ravin Kumar for R1.
Bhaskar Rao.
Take that. No, I have written here.
Yes, yes. All right.
Who is appearing the seventh respondent, Mr. Prabhakar? Huh? No. Who is appearing for the seventh respondent?
This thing, right? This 1 minute. Show madam. Don't write this. Praveen Rao and Prabha.
Take it from my book. It is there. I have put it back.
In this order, it will be there. But in this, what his presence you take from his copy. Okay. So 26.
Who is appearing for the seventh respondent? Why is it necessary?
Your Lordships, the reason I have put the seventh respondent, Your Lordships, is once the bifurcation issue is there, it becomes imperative that their input is also taken, and therefore I have put it here.
They will support you, right? Hey, why you are stand on your own? Then when that issue notice to respond number 7.
It can't come on.
Then I will
list.
I'll not press.
List as
Lordships, I'll not press with respect to this.
Then petitioner undertakes to delete the name of respond number 7 from the cost title. 7, no?
7.
Let this be done during the course of the day.
GP will take. Ninth respondent, AP. Govind Reddy, P. Govind Reddy, Special Standing Council. Not for medical.
Why don't you dictate for this?
No, but then in which case, even ninth, if that is the case, we'll have to order notice.
Ah,
That GO is not in question, Your Lordship. I'll not press that also.
Now, please.
so which respondents you are deleting?
Seventh and ninth.
Seventh and
Undertakes
ninth.
to, beginning you write, madam, undertakes to delete the name of, delete the name of respondents number 7 to
Seventh
9.
and ninth.
7 and 9.
7 and 9. Let this be done during the course of the day, then you in the beginning write, Union of India, Mr. Number 1, Mr. Praveen Kumar accepts notice on behalf of respondents 1 and 2. Mrs.
Ujita.
Srirang Pujita, Learned Council accepts notice on behalf of 3. Then Mr. N. Praveen Kumar, GP for health.
Medical and
5 and 4 and 5. 4 and 5. Mr. G. Praveen Kumar accepts GP for health. Health and family welfare. Accepts notice. Then
Sixth, who is
sixth
the
is Mr.
Answer this.
sixth respondent? Vijay Prashant.
Vijay Prashant.
I have.
What's your name?
My name is.
Ekavan Judge. I'm representing on behalf of the Vice Chancellor.
Write her name. Accepts notice on behalf for Mr.
Vijay Prashant.
Vijay Prashant, Learned Standing Council for respond number 6. Then 8, Mr. Prabhakar Rao, Learned Council, accepts notice on behalf of respond number 8. Then that order goes, right? Service complete, and that the order goes like whatever we have dictated. List on 6th of September. All right. So then 26, Mr. Call, Madam 26. We don't want to get into any confusion. Give, Madam. Order has been passed. Mr. Prabhakar Rao. Give.
26.
Order has been passed, right? List along with WP number 23100/23 on 6/9/23. 27.
In fact, Your Lordships,
27.
in 26, 28 and 30, Your Lordships, there is a direction. If the petitioners are not found a seat or admission in the 20 colleges, then their status with respect to the 34 colleges may be stated in the in a sealed cover. Your Lordship.
Admit them, provide a scholarship. What you are talking about, the declaration, Mr. Expectation of the,
Direction was
just a
put in
minute,
a sealed cover.
lighter when we are saying, don't be so serious all the time, right? Nothing is being done. So Mr. Rao, you are saying that they can't be considered, they want consideration, admission and scholarship free, everything for 5 years. And if possible, declaration of degree, also convocation ceremony at 5:30 PM in the High Court premises, Dr. So and so. And felicitation ceremony for the council who made it possible in one day. This is the expectation. We can't. Yes, what do you want?
The direction was that Your
This
Lordship,
is, again, it is listed what for? We have passed an order.
their candidature may be considered and put in a sealed cover, Your Lordships.
If they have not complied with the, what is the remedy?
Obliged, Lordship.
Fine.
Obliged.
If it is coming up on 6th, we hope that you will not complicate the matters by filing a contempt. Otherwise, we will hear contempt and leave this petition, this thing, correct? Acha, what is the order passed in this case?
27.
9/8. No, there is no order in your case, this. 18216, no order. This is only order is admitted for hearing, no interim order. But their case will be considered. No, 20 colleges.
20 colleges they will be considered.
Well, give that, madam. This just now correction thing I have given. correction. Carried out correction. This correction is carried out, no? Carried out, no? So, learned counsel for the petitioner submit that the issue involved in this writ petition is similar to that in WP 23100/2023. Therefore, the
petitioner.
delete. Then you should say that you are saying, Mr. making submission that they should be declared and all this. What does this mean? That you are making submission in item 26 and
Yes.
now you are saying when we are passing an order, now you are saying I am not the counsel.
27, I am not the counsel. I was making my
26 you are not.
26, I was making my submission.
Huh?
This is somebody else.
So 26 we are passing in order.
26 we have already passed them.
26 we have already passed an order.
Yes, your lordship. 26, there is an order.
No, madam, 26 what order has been passed? 26. Now this is 27, right? Tirumal Rao. You are Mr. Tirumal Rao.
Anup Kaushik, your
He is showing online, my lord.
27, I am.
Please sit down.
Is there online?
Please sit down. 27. This is 31, madam. I-
27, I'm appearing, my lord.
See, this 31 is written. Wrong. 8216.
From 26 to 31,
8216. Similar interim order. Mark the, don't mark anybody's presence.
My lord,
In view of interim order,
I'm appearing, my lord.
you have filed SLP because we are. Have you filed SLP?
No.
No. So we are granting you similar cases. Interim order granted that your candidature be considered against 20 colleges, right? And the matter is coming up on 6th. Same order in your case, even if you don't want it. Appear through video conferencing. For the controversy involved in this, heard learned counsel for the parties, the controversy involved in this petition is similar to the one involved in WP number 23100/2023 paragraph with a view to maintain parity and for the reasons assigned by us in the order passed in WP number 23100/2023, it is directed that candidature of the petitioner in respect of 20 medical colleges established prior to 2/6/2014 shall be considered, and in case he is found eligible for admission, an affidavit shall be filed or a submission shall be made on behalf of the university in this regard. Learned counsel for the university, press warrant is granted a week's time to file counter affidavit list on 6/9/2023 with WP number 18047 of 23. Next.
27 also goes along.
1 minute. 27 is order has been passed just now in your case. 28.
28, there is already an order, your lordship.
28.
Nothing. Learned Mr. Prabhakar Rao, learned standing counsel for university, press warrant is granted a week's time to enable him to file a counter affidavit or file a memo adopting the counter affidavit filed in connected matters. List on 6/9/2023 along with WP number 18047 of 23. Next matter. 29. 29.
There is already in order.
Yes, Mark, the same order which we passed just now, that Mr. Standing Counsel for University, just now we have typed, madam, list along with 6/9 on so and so, right?
There is an interim order.
There is an interim order.
Same order, write his presence and list along with on 6/9.
The 21 also, 31 also same.
Same. 31 same, learned Standing Counsel, just now you have typed 6/9. 32.
32 to 49, your lordships, the order passed in 25 may be passed.
32 to
49.
49.
The same order has passed in
Yes.
6 lots.
Huh?
Item 6.
No. He has a additional prayer, no, which we said that we can't,
Premature.
he wants. Item 25, right?
Yes, Your Lordship.
Mark the presence, appearances, etc., everything like that, what you have this thing. And item number 25, order is in
32 to 49.
32 to 49. List along with so and so on 6th 9. So, item number?
To comply with the order. Which is my respectful submission is that we have deposited the amount with the Kala Lordships.
No, you have to file a compliance report.
1 week may be granted to me, Lordships will file that. Because the deposit amount,
No, 2nd August, we granted you time for compliance, mister.
Lordships.
There is absolutely no justification after dismissal of SLP.
My respectful submission is that we have, still only got deposited that.
No, my lord. 9 months to 22nd, 2022, our award is passed. They went review several matters that look like this. Lastly went up to
We will
Supreme
proceed against him.
I submit my lord.
No, what we will say is that let him file a compliance report failing within 1 week, failing which on the next date of hearing, we proceed against him in the contempt petition. Right?
Plus one more submission, my lord.
Then don't argue on the next date, right? You say that we have not complied. We will proceed.
Sir, for last 9 months, the accrued interest is 43 lakhs now. And the awarded amount.
Mister, your object is to enforce.
Yes.
If he goes to jail, suppose if he order imprisonment, he will say that it be kept under suspension, I will file SLP. So, no, the purpose will not be served, right?
Yes, you are right.
You convey, mister, there is no other go but to comply.
Obliged, Lordship.
And we can ensure that he will be kept behind the bars till he complies.
Obliged, Lordships. Fortunately, they are watching, Lordships. Right. Fortunately, they are watching all.
Watching, no, correct. That's very good that the message goes to them that they have to comply, no other this thing. So the orders of the court which have been upheld by Supreme Court have to be respected, no other this thing.
Obliged.
And you have been, they can't do like this. They are all private this thing, respondents, right? NHAI.
HAI, Lordships.
Said,
14 years.
see, somehow they have a sense of like NHAI, what do you think that above law or something like that, right?
10 years back.
No, not like that. You will dispel that impression if they have.
It's not like that.
No, mister, you will tell them that they are bound by the orders of the court.
Lordships, I convey. Again, I'll convey.
Again, this petition has been filed for violation of order dated 14/3/2019 passed by a division bench of this court in WA number 133/2019. Full stop. On 26/7/2023, this court had granted adjournment in view of the prayer made on behalf of the respondents that against the judgment dated 14/3/2019 passed by and no prayer for adjournment shall be entertained. You understand, right? Ah. You do it and the appeal under section. There are defined grounds for interference. We are arguing, we will record that the previous submission of proposal find the quiet work concept transaction. And this is not one of the ones in the section 34 and therefore appeal distance. If it's sorry, once it took. Yes. Now pleadings are complete, right? What is this CRP?
Under the architect bracket.
Huh?
Commercial board attached with the bank account. On the ground.
Notice has been issued, right? And it's for admission, right? We'll admit it. Petition is admitted for hearing.
It is coming for counter offering then.
In this case, my lord, after filing of the writ petition, he filed an amendment petition to the order last occasion. I have to file counter affidavit after the amendment petition is allowed, my lord. I request some more time.
Petition is, we'll admitted for hearing. Learned counsel for respondents pray for and are granted 4 weeks time to enable them to file.
In 53 and 54, I'm appearing for respond number 1, my lord. I just received remarks in these two matters. I need 5
Inner council designation.
None for the petitioner.
The respond number 13 may be deleted, my lord, because
13.
no,
Yeah.
no. It's become elevated.
Oh. Office is directed to none for the petitioner. Office is directed to delete the name of respondent number 13 from the cost ID.
I'm appearing for respond number 1 in two.
Learned counsel for respond number.
I'm for second open. No petition.
One.
I'm second.
Yeah, 1 and Mr. Praveen Kumar DSCI
Second respond.
for respond number 2. Pray for and are granted.
For GA.
No, appearing is fine, right? We are concerned with what do you do thereafter at this stage. Tell Mr. Praveen Kumar what he wants. Ask him what he wants. He is looking, he is appearing, so that's fine. His presence will be recorded. So what he wants, nothing. Ask him. He is looking, you listen to what Praveen Kumar is saying.
Remarks has been received in these two matters, my lord. I need 3 weeks time to file counter.
Learned counsel for respondent number 2, praise fund is granted 3 weeks time to enable him to file counter. You should say at least that I don't want to file a counter. Appearing is fine, right? Appearance she does. Your mark. Give it a slip and don't look at us. Give it a slip to her and it will be recorded.
And during the respondent.
The inquiry being made is whether you want to file counter. You should say, I don't want to file counter. Say so then. This is not in wedding going on here that we distribute invitation card, then only you will say that I will come. Nobody is getting married, right?
I'm repeating respondent number 1 and 3, my
Yes.
lords. I request 2 weeks further time to file the counter, my lord. Respondent 1 and 3.
We'll admit on this. Admitted for hearing. Learned counsel for
GP, respondent 1 and 3.
GP 1 and 3. 4 weeks time to enable him to file counts. So correct, like till 1 year expires, you will not file counter. We will set you right, Mr. In some
I can understand.
now onwards.
Sorry, my lord.
If you not filed, all of them will appear to explain their conduct of.
Yes.
No, we have been told by brother. The tendency is not to file counter till 1 year.
Because it is a case.
So change that perception.
The case, my lord, file for the payment of the.
Fine. We don't know, but we are generally telling you not about this case.
Requesting time for filing.
Change that
counter.
perception. All cases.
Yes, sir.
That you must respond by filing counter.
Requesting time.
When you assure a new judge that bar will cooperate, and Advocate General has assured us that this is the cooperation.
Sure.
Correct.
Requesting time for filing counter, your lord. I'm appearing for.
Who is speaking?
I'm appearing for first and third respondent, your lord.
You are praying. Learned counsel for respondent
Requesting
number
time
1
for
and 3. Praise warrant is granted. How much time?
3 weeks, your lordship.
Admitted for hearing. Learned counsel for respondent number 1 and 3. Praise warrant is granted. 4 weeks time to enable her to file counter.
Readings are completed.
Pleadings in the case are complete. Petition is admitted for hearing.
My lordship, we have filed counter.
What is the state? Yes. No. Status of departmental inquiry not 5/12/2020. None for the parties. Let status of the departmental inquiry initiated against the petitioner be apprised on or be placed before this court on the next date of hearing. List after 4 weeks. $59. At the end of the list.
Your lordship,
End of the list.
the lordships are directed me to submit a synopsis.
Take it up
Just-
when the matter.
Yes, very well.
Today board appears to be clear. So the legal education now after MBBS.
Very well.
Legal. All these candidates we are concerned who are losing 1 crore per day. So we wish that from the date of judgment they start earning
Very well.
1 CR a day.
Blessed.
Yes.
Last occasion, notice was ordered to the implicated respondent.
Counter.
Notice was ordered to the implicated respondent.
Madam, served or not? Find out. Newly impleted, served or not? Await service of notice on respondent number 6. Let counter, if any, on behalf of respondents be filed within 4 weeks.
In this matter, respondent needs to file the counter.
They are not filing. What in all cases not filing, right? Wherever Mr. Prabhakar appears, they don't file. Petition is admitted for hearing. Let counter, if any, on behalf of respondents be filed
My lord, sir.
in 4 weeks.
My name is wrongly reflected from Medical Counseling Committee. Notice will have to go to it, my lords. I appear only for the National Medical Commission.
Write her name, before Mr. Prabhakar, and then Madam says that she is not appearing for
Medical Counseling Committee, my lords.
Medical Counseling Committee. In view of aforesaid submission, issue notice, personal service, proof of service. Let counter, if any, on behalf of respondents be filed within 4 weeks. Admitted for hearing, right?
Obliged.
Yes.
May please your lordships. May please your lordships. Let's this matter pertain to removing of the sports quota under UGC NEET examination, Millets. Wherein the Sanabu court pleases to.
You are a sport quota person.
Yes, Millets.
What sport do you play?
Playing rifle, Millets. Playing rifle. Shooting, Millets.
Shooting.
Millets.
Shooting.
He is a coach also, Millets.
Coach also.
Yes, Millets. Millets, that
shooting only targets not people, right?
Because
shooting only targets, no, not people.
No, Millets. Only shooting is the only target. Petitioner target is only.
Request for time for counter.
Why are
Connected matter is there, 21419 of 23. Same.
21419
of 23.
21419
of 23.
Admitted for hearing, list for analogous hearing along with WP 21419/2023. Learned counsel for respondents. Praise for is granted. 2 weeks time.
Millets.
To enable him to.
May permit to submit one thing, Millets. Millets, interim direction may be granted, Millets, because second round is going to open.
File an application. Application.
The same may be observed. Millets. I will.
File an application. Move memo.
Let's.
We cannot grant you liberty in anticipation. You move whenever second round of counseling is notified, come. Yes.
Much of
This, admit, I pray your lordship grant some more time for filing counter.
Admitted for hearing.
I request some more time for filing counter.
Respondent. How much time?
4 weeks.
4 weeks time to enable him to file counter. This is a stipend, right?
Yes.
You will get a certain sum of money. You will get it when petition is allowed.
Yes, but only problem is they announce the results. They announce the results by hiding these 3 months. So once that's done, you have to be, I mean, it's again, becoming more complicated. Because no, 3 months, it's has to be this how full bench that.
No, Mister, but the rule is there, right? Rule is there. Mister, you should examine that the rule is contrary to his submission is full bench.
Yes, he participated after 1 year, Millard. After entire process is over, he filed petition only last month.
Because this is going to happen at the end of this election. So therefore now.
No. Who are you?
I'm the petitioner.
No, obviously petitioner, but who are you means what is the status of the petitioner? That's what we are.
Qualified. Petitioners are qualified, but not having.
Qualified for what?
Qualified for the police constable.
Police constable. When did you participate this thing? You are constable?
The candidates.
Aspiring candidate.
When did you participate in the recruitment process?
It started.
When did you participate? Specific.
Different stages are there.
So when it began, when?
Up to 28 August 2022. And final happened on 30th April 2023.
30th April?
Yes. 30th April 2023.
When did you file this petition?
5 minutes, 2023.
On 31/7/23.
31/7/23. But at least don't, I mean, fold hands when you are addressing this court. You can do in the corridor, right? We told you. So 30th 7. So after nearly 11 months of participating in the preliminary examination, 1 minute, we are asking question, not deciding. The file has gone there. So 11 months you have filed the petition. What is the relief in the petition?
Only we not see they are.
You are striking down, seeking striking down of a rule.
Yes, ma'am. So that is.
Rule pertaining to recruitment, which is a statutory in nature.
Yes. And where.
So, can we adjudicate the validity of the rule without counter, or in a cases where validity of the rule is challenged, they should be given opportunity to file counter.
Yes. But
So we are 31st July you have filed the petition, not even 1 month from filing of the petition.
yeah, first time after 3 weeks periods.
Huh?
So they already took the time.
No. So see, Mr. Petition filed on 31st July 23 cannot be allowed on 31st July or 1st of August 23. For that wonder, you will have to become a judge of this court. We are incapable. We are fallible human beings. We cannot do it. You can do magic. That 31st July petition filed, you will be judge. We will be arguing before you and expecting that within 24 hours without counter, all allowed, and everything is quashed. They are sent to jail and everything is done. So this is what it is. I mean, it's like waiting for 11 months to come to this court and wanting that within 1 month everything should be over. If result is declared, you know the position. Merely because they are going to declare the result, this petition cannot be heard today without counter. What he is required to do is, he will go to Supreme Court and say that I was praying for time. This person has waited like this for 11 months, and court once gave 3 weeks time to file counter, and next day allowed the petition.
Maybe shorter date, maybe like 3 days.
Everything has a limit. We are wasting time on you because this is also waste of time, this conversation. You are a sufficiently experienced person. You understand, right? So it can't be done. If you want any interim relief, move an application. Don't restrain them from declaring result, whatever, and say that it should be heard. That is understandable. But it can't be heard.
The stay which action 3 days for that. Stay under the
That we can hear. We can hear. Waiting, we'll decide it. So what is the, give madam, what is her? Place for 4 weeks time to file counter. Heard on the question of interim relief. What is interim relief? That they should not declare the result. They
can proceed with the whatever the process, but the announcement of the results.
So the state doesn't need any constables, right? Any further constables, according to you, they are more in number. So no, Mr. Lighter, when we may share that even in Chief Justice's court, like there was no constable. Today only morning we asked RG that there should be someone. So this is it. And you are saying that all posts should be recruited, stalled.
But not against the pay chart. That's only the concern. Because they are adding 6 smart meters. That is no even 0.5. There are hundreds of.
All right.
There are 54.
What is the interim relief? Yes. Learned counsel for the petitioner submitted. Heard on the question of interim relief. Learned counsel for the petitioner submitted that this court that the implementation of weightage of 3 marks for light motor vehicle driving license dated contained in the GOMS dated 8/4/2022 issued by State of Telangana on State of Telangana for recruitment to the post of constable be stayed during the pendency of the petition. Paragraph. We have considered the submission made by learned counsel for the petitioner Full stop. The petitioner has sought the following main relief in the petition quote main relief page 17, right? Thus it is evident that the main relief and the interim relief paid for by the thus it is evident that in case the uh, full stop, it is straight law that the court would stay the operation of a statutory provision only in exceptional circumstances. No exceptional circumstances have been made out by the petitioners in the instant case. Full stop. The preliminary examination for recruitment to the post of constable was held on 28/8/2022. The petitioners, with their eyes wide open, appeared in the examination and have even appeared in the final examination, which was held on 30/4/2023. Thereafter, at the stage of declaration of the result, the petitioners have filed this petition on 31/7/2023. Full stop. In view of the fact that the petitioners have failed to make out any exceptional circumstance for a stay of the rule, as well as their conduct, no case for grant of interim relief is made out. The prayer for interim relief is rejected. The needless to state that any recruitment, if made to the post in question, shall be subject to outcome of this petition.
Lord, I appear for the respondent number 1 in this matter. Lord, we are a formal party in this said writ petition.
I'm appearing for respondent 6 to 8. My lords, we request 2 weeks time to file the compliance report. My lords, I appear for respondent number 9. Formulating. A task force committee has already been formed in
You are
respondent number 6 to 8.
learned counsel for respondent number 6 to 8.
My endeavor, as a petitioner, my lord, my endeavor is that, my lord, the respondent number 7 categorically stated that they have no instruction from respondent number 2 and 3. Even though respondent number 2 and 3 stated that they have instructed respondent number 7 to take action against the respondent number 9, they stated that they have no.
Doing what?
As the respondent number 9 is emptying pollution.
Dangerous fluids into your body.
Yes, sir.
So, all right, lighter vein, so water body. So, polluting water body.
Yes, sir.
So,
3 and 4, my lord.
1 minute. So, who is 3 and 4?
Revenue department. 3 to 5, not IPM.
What you are?
Because page 24.
Water bodies are being polluted. You are what?
Page 24, Lord, action has been initiated, Lord.
What?
He himself filed page 24 on 7/9/2022.
So,
The
7/9/22 is almost next month. We'll be completing one. You want to celebrate anniversary of initiation of action.
Submitted that already task force has been constituted, my lord, for examining on the issue.
Page number
by next week adjournment, my lord.
6 to 9.
Yes.
Yes, madam. We should impose your on account of your inaction. So much of litigation is generated, right? People, no. Generally, we are telling you, since you are appearing for Pollution Control Board, people make a complaint to you, you sleep. Like famous character that of Mahabharata, 6 months you sleep. So moment they submit a representation, you go into slumber for 6 months. And wake up only after you receive notice from the court.
My lords.
And then you seek time to file committee and this thing. No, madam, this is something serious. If the action was initiated on 6/9/2022, you have to explain what have you done for 1 year and why you did not this thing. This thing, you cannot have this callous sort of an attitude. You have been constituted to check pollution, not to engage counsels and argue in the High Court. Are you a body meant for this thing, High Court? So a body constituted, this thing preamble should say, a body constituted to constitute to contest elections, writ petitions in the High Court and to oppose the, and thereafter when the orders issued by High Court are upheld by Supreme Court to implement the orders. This should be your object, right? Well, it is so, madam, it's not that you are appearing for Telangana Pollution Control Board for the first time. But we have been seeing for past, like this is my 5th week into this court, and not a single day has passed where Telangana State Pollution Control Board is not a party in proceeding. Grievance say no action taken. When will you improve? So therefore we wonder whether you are a body constituted for people or you are anti-people.
One submission.
He is making a complaint, you should have looked into it, right? Told us, this is not our job to prevent. High Court is not constituted to prevent water bodies pollution. Otherwise, we will disband you and take upon ourselves the task. People can directly approach us by filing that this is the grievance. We will fix one of our registrars who will be very efficient judicial officer to look after the complaints of people regarding pollution. You don't exist. You prepare a panel of advocates, right? Different panels of advocates who appear in different cases, pay them fees, contest the prayers, and take litigation to Supreme Court. This is all you are meant for. Disgusting, madam, disgusting. Someday we will have to summon your chairman. The way it's not far off. That day we can see it's not far off then when you have to summon your chairman and save questions which we are putting. That to prepare a panel of advocates for high courts, district courts, everywhere, in the Supreme Court, pay them retainer fee, contest litigation, not take a sleep over the complaints of people who approach you. After 1 year, tell the High Court that we have constituted a committee. You will have to account for what have you done from date of receipt of this petition. No, serious issue, madam. Serious. We are not telling you as a person. It is to Telangana State Pollution Control Board because you by chance represent the board today at this point of time. No, report means not report. Committee constituted, nothing found. No, nothing found and matter be closed.
Page number 20.
You will have to explain what have you done for 1 year. When did you receive notice of this proceeding?
Page number 25.
One minute. We are not passing any adverse order against you. We want to this thing. Give a message. When did you receive notice of? When was this petition filed, Mister? No. When did you give the representation to the board?
Okay. I have given representation on 14/10/2022.
14/10/22 representation to
the respondent number
board. Then when did you file a writ petition?
I have filed a writ petition on 14/7/2020.
14/7/23.
My endeavor,
notice was served to you, madam. When are you appearing? Since when you are appearing? First time.
Matter came up on 3rd August. Matter came up on 3rd August, my lord.
3rd August.
Yes, my lord's order notice for the unofficial respondent.
3rd. Today is what, 24th August, right?
Yes.
Appeared. All right, she has been served with the notice.
One submission. Page number 25 is very.
So, madam, you will tell in the action taken report that petitioner made a complaint on 14/10. What did you do till your appearance before this court?
Only one submission. Page number 25.
Let her submit a report.
25, they have stated that they have not received any representations, even from the revenue department also. They categorically stated.
No, so where is the seal of your representation dated 14/7/2022?
14/10/2020, page number 17, my lord.
17. Is there an endorsement? By what means, like Many a time these representations are prepared in some offices of officers of this court. Right? I mean, we have found it, not in this case. You may be having, by what this thing means, you send it to the board.
No, my lord, one submission.
No, no.
Revenue department categorical.
1 minute. 14/10/2022, you said that we have sent it. So where is the acknowledgement? What is the, which mode it was sent, personally delivered? Where is the receipt?
Page number 19 is the other representation.
90.
Through post.
Post.
59.
Acknowledgement. No, you, Hare Krishna. Is it so confusing, right? That
only one submission.
You get like confused, like what will happen if Keshwanand Bharti is reviewed? Huh? You are getting confused like this, right? Simple question that you submitted a representation, you told to Pollution Control Board on 14/7.
Yes.
You said that it is at page 17.
Page number.
We are asking you by which mode, there is no acknowledgement.
There is no acknowledgement.
No seal. So by which mode it is sent?
They have stated in their RTA report, my lord, that I have some submitted.
No, you tell us, you are the petitioner. You are petitioner.
Yes, ma'am.
You tell us by what mode 14/10/2022 was sent to Pollution Control Board and when it has been received.
I have given by hand out.
Acknowledgement.
Acknowledgement they have not given.
Which para? Hand where you have made a statement like this?
Page 17. Not page 17, my lord.
Huh?
Page 17.
Page.
Page 17 is the correspondence of the fourth respondent to the Pollution Control Board.
Which paragraph, Mr.? About P8 by hand and did not give acknowledgement. Which para?
Page number 17, my lord. Page number 12, my lord.
In the pleadings.
Read petitions.
Yes, my lord.
Because it has to come right that petitioner visited House of Pollution, handed over person, but they refused, despite retaining copy of the representation, refused to give acknowledgement. Where is this statement?
That I have.
Just now you said, right?
Yes,
By hand.
Yes, my lord. Representation I have not filed before this honorable court, my lord.
You
only with
Mr.
that, along with that
You
representation.
just now you said page 17. How, Mr.? Your memory is so short, right? 2 minutes ago, what you said, you feel, you forget. We are remembering. You said I have given representation. You said 14/10. We asked you where. You said page 17.
Page 17
this page 17 is not an acknowledgement. We are asking you. You said I gave by hand and no. There is no averment.
No, I have given, but I have not filed it. It's true that I have not filed it.
Learned counsel for the petitioner during the course of submissions orally submitted that he had submitted a representation to which, to whom? Representation to?
Representation to the respondent.
Member Secretary, Telangana State Pollution Control Board Office, Hyderabad on 14/10/2022. Full stop. Paragraph, we have perused the representation dated 14/10/2022. The aforesaid representation does not bear any postal acknowledgement that the member secretary of Pollution Control Board has received the same. Paragraph, when a query was put to learned counsel for the petitioner as to by which mode the aforesaid representation dated 14/10/2022 was sent.
I'm sorry.
Learned counsel for the petitioner states that the petitioner had handed over in person the aforesaid representation to the in the office of the Pollution Control Board and the acknowledgement was not given. Paragraph, when a further query was put to learned counsel for the petitioner as to the averment in the writ petition in this regard, learned counsel for the petitioner fairly conceded that the writ petition does not contain any such averment. In view of aforesaid, petitioner is directed to file an affidavit with regard to service of representation dated 14/10/2022 and to file the acknowledgement, if any, in the possession of the petitioner on or before next date of hearing. Learned counsel for respondent 5, 6 and 7 shall file 6, 7 and 8 shall file a status report with regard to pollution in of water body. Which water body, madam? Water body, namely Sambaya Chiruvu, on the next date of hearing. List after 2 weeks. File an affidavit. We want to curb this practice of, you know that it is prepared, may have been prepared in your office, you don't know, you are a senior person.
Only one submission, my lord, upon the.
So, no, your junior must have said, oh, you have come here, where is the representation given? I did not give. We will prepare one in no time.
It's not so bad. It's not so.
Which show, why does it not say that safest mode to give it by registered post? Acknowledgement due.
Because
that's why we have kept it open. File an affidavit. It may have been sent by registered post. You may be having acknowledgement.
Acknowledgement is not there, sir.
How do you know? Therefore, please file and ask the petitioner to file an affidavit. If you are found, it is found that you have not approached the court with clean hands, you will be ousted. You will be ousted from this petition. We will treat it as public interest litigation, suo motu register, and appoint someone as amicus. We will take up the cause. What is important is cause, not publicity.
My only endeavor is, my lord, revenue department directed them to.
Endeavor is not to get publicity.
Yes, correct.
Only endeavor is not to get publicity.
It's true, my lord.
Correct. Yes. Yes, Mr.
And as directed by your lordships, my lord, I have filed my counter.
I
have filed my counter.
All right. So what is it, Mr.? This is to be heard.
Yes.
I'm going to respond number 12, my lord. In fact, it would be.
What do you say? Yes.
Sir, party in the person, sir. Party in person.
కౌంటర్ వచ్చిందా
సార్
కౌంటర్ కాపీ వచ్చిందా
వచ్చింది సార్ ఎంఎస్ఆర్ కన్స్ట్రక్షన్స్ భద్రాద్రి కొత్తగూడెం డిస్టిక్ లో ఒక్క మండలంలో 22 వర్క్స్ అవినీతి అక్రమాలకు పాల్పడుతున్నాడు అనేది మేము కేసు ఫైల్ చేస్తే ఆ భద్రాద్రి కొత్తగూడెం డిస్టిక్ లో ఒక్క మండలంలో 22 వర్క్స్ గురించి రిపోర్ట్ ఇవ్వకోకుండా అడ్వకేట్ జనరల్ గారు అది డిస్టిక్ లో ఇచ్చాడు సార్. ఇంత పెద్ద ఫైల్ ఇచ్చాడు.
అడిగినావా నువ్వు? అది
చదివాం సార్, చూసామని.
రిప్లై చేసేది ఉందా లేకుంటే అవసరం లేదా? ఏమన్నా రిప్లై చేస్తావా?
సార్ ఎంక్వైరీ అంటే చేసుకో, అన్ని డిస్టిక్ లో మాకు అవసరం లేదు కదా సార్. ఒక భద్రాద్రి కొత్తగూడెం డిస్టిక్ లో గుండాల మండలంలో
చేసిండ్రు, దానికి కౌంటర్ వేసిండ్రు, దానికి రిప్లై చేస్తావా?
You have filed reply, no? You have filed counter files. Want to file any reply? Ask.
రిప్లై చేస్తావా? అవసరం లేదా?
అప్లై మీకు మొత్తం ఫైల్ చేశాను సార్. అప్లై చేయండి, మళ్ళీ అప్లై చేసుకుంటాము.
రిప్లై
రిప్లై అంటారా? రిప్లై చేస్తాం.
రిప్లై చేస్తావా అని అడుగుతున్నా.
చేస్తాం సార్.
మరి ఎంత టైం కావాలి?
సార్
ఎంత సమయం ఎంత కావాలి రిప్లై చేయడానికి?
మీరు మాకు ఒక 10 minutes చాలు సార్.
10 minutes లో రిప్లై చేస్తావా?
రిప్లై చేయడానికి అంటారా? రిప్లై చేయడానికి కూడా మాకు ఒక వారం రోజులు టైం ఇవ్వండి. ఇంత ముందు మీ సీట్లో ఉన్న మేజిస్ట్రేట్ వాళ్ళు సార్ 6 జూన్ 23 ఆర్డర్ ఇచ్చారు సార్ వాళ్ళు.
ఒక నిమిషం, నువ్వు ఇప్పుడు అక్కడ నిలబడి ఏం చెప్పినా ఇది కాదు, రిప్లై చేస్తా అంటున్నావు కదా, నువ్వు చెప్పేదేదో రిప్లైలో రాయి.
ఓకే సార్.
How much can you say? 1 week. 1 week. 14% petition is admitted for hearing. 14% learned senior
Respondent number 12, my lords.
Learned counsel for respondent number.
Madam, the official respondents, madam, from
Official respondent and learned senior counsel for respondent number 12 submits that they have filed counter. Paragraph in view of opposite 14% praise for and is granted a week's time to enable him to file reply to the counters filed on behalf of respondents.
My lord, I beg to represent Mr. Dinesh Millard.
Yes.
My lord,
Yes, Mr.
my lord, this PIL filed, my lord, unofficial respondents, my lord, some of the unofficial respondents, my lord, encroached the public body water tank. My lord, notice was issued, so far counter not filed. My lord,
They don't want to contest because president of the bar is appearing.
no, my lord, apart from my request, my lord, petitions also.
Still not standing up anybody, including Union of India. They also don't want to contest. We know that. What in an enforcement you have to do. But see, we are just telling him that since president is appearing, nobody wants to oppose.
I'm sorry, my lord.
Yes, mister. Why should you not file counter?
I'll inform the concerned government leader that I am not appearing in this matter.
Advocate General Harendra Prasad, praise warrant is granted, 3 weeks time to file counter. And directed the matter to be listed today. This happened on 2nd August 2023.
Petition is admitted for hearing. Let counter, if any, on behalf of respondents be filed within a period of 4 weeks.
May I request lordship subject to, that already petition file a complaint, my lord, before the respondent, that same is pending.
Let them
dispose the.
In the meanwhile, it will be open for which respondent, Mr.
My lord, what? Respondent.
In the meanwhile, it will be open for respondent number. No, the only thing is, Mr. Rao, you know, what is our predicament?
My lord.
That they will pass some order in pursuance of interim order. These respondents whom you have worried,
yes,
they will file another petition.
My lord.
So, one petition, one interim order will give rise to one more petition. So why don't you wait till these people?
I leave it.
2 weeks time to enable them to file counter, and private respondents have been served.
Yes, my lord. Served, my lord.
None for respondents, then, right? None for respondents. 13 to 27. Those served. Madam, served? Proof of service?
Yes, filed, my lord. One of the friend appeared, appearing, my lord.
These brown envelopes are kept there, madam. See how.
My lord, 16th to, my lord, 27 appearing, my lord.
This is 3/16 to 27.
One Mr. Sudhakar filed, my lord, is out of station.
Nobody entered Wakalat, Mr.
Mr. Sudhakar name, my lord, appeared in the cause list, my lord.
Wakalat is not there.
Let counter, if any, on behalf of private respondents be filed within a period of 4 weeks, within the aforesaid period, list thereafter.
Obliged.
My lord, I appear for the respondent number 9 in this matter. We have filed our counter affidavit in this matter.
I'm for the petitioners, my lords. The
1, 3, 4, and 5.
4 and 5.
I appear for respondents 2, 6, and 7 have to file their counters. GP for revenue. 2, 6, and 7 will file our.
And what about 1, 3, 4, and 5?
They are filed.
It is stated that respondent counter has been filed on behalf of respondents number 1, 3, 4, and 5. Let counter, if any, on behalf of respondents 2, 6, and 7 be filed within a period of 4 weeks. At this, in the beginning, you write admitted for hearing. Yes.
Blush.
Proper vaccination has to be done. What steps? Para?
Page 3.
Third, we have mentioned about ABC program, animal birth control program and anti-rabies program. Taken up by TSHC, but the
I don't know, that's always taken up on paper. We want figures, how many?
page number 4, my lord, the figures are page number 4, para 8.
Para?
8 and para 11, my lord. Para 11 are the statistics, my lord. Around 50,026 dogs have been treated. They are sterilized in the city of Hyderabad. Para 5 is the table.
So then, Mr., how many dogs left according to you? Or everything, everyone?
400 to 500 dogs are being sterilized in the city, my lord, daily.
No, that
daily
is understood.
My lord, we have
This is
mentioned
about
that.
these figures of entire state?
No, my lord, only Hyderabad. Concerned to limits of Hyderabad. THX.
All right, so what else is required to be done? It looks all very
All
fine on
steps
the
have been
paper.
taken. All steps have been taken regarding feeding also. my lord. The other prayer is regarding feeding of the stray dogs. We are taking help of 5 animal welfare organizations which are recognized by Government of India, my lord. And regularly they are, even dog lovers in the city of Hyderabad, they are providing.
When was this report filed?
This counter was filed on July 2023, the latest statistics.
How many stray dogs according to your record? All of them vaccinated?
No, my lord.
Yeah.
Around 50,000 dogs have been vaccinated, my lord. 50,000 sterilized and vaccinated.
And
Birth control program is also initiated.
and how many stray dogs according to your record?
There are around 2 lakhs is.
Yeah. Long way to go, right?
Yes, my lord.
Huh?
Yes,
Only 25%.
capacity 500 per day, my lord. They are catching.
Keep on doing. File a status report.
Yes, this is the latest status report. We'll file further.
Arey, Mister, you should understand that according to your own figure, there are this thing, 2 lakh dogs, right? You have done only 50,000.
I'm sorry, page number 6, my lord, the latest statement also given, my lord. It is 2,17,780 dogs.
2,17,780
dogs. The date of vaccination done by GHMC
and
from
sterilization and vaccination is 50,000.
No, my lord, this is the latest one. Subsequent paragraph in page number 6 is the latest report, my lord. 2,17,780. Page number 6.
No, you have done it.
Yes,
2,17,000 sterilization and vaccination.
Yes.
So you told us 2 lakhs, and there are more dogs you have already.
I'll
70.
come up with the figures regarding how many dogs are there. I'll come up with the latest.
Yes.
Yes.
In this writ petition, the issue involved is with regard to vaccination and vaccination and sterilization of street dogs, as well as full stop. The writ petition also raises the issue of feeding and looking after the welfare of stray dogs. Paragraph. Learned Counsel for the GHMC submits that while inviting the attention of this court to paragraph 8 to 10 of the counter affidavit, submits that the GHMC so far has sterilized and vaccinated 2,17,780 dogs in the city of Hyderabad. It is further submitted that full stop. What welfare measures have you taken?
There are even dog care centers. 5 dog.
No. Feeding of the stray dogs.
Feeding of stray dogs
and looking after.
There are 10, my lord. There are 5 animal welfare organizations.
Paragraph. Learned Counsel for the petitioner submits that the GHMC has involved 5
animal welfare organizations.
Animal welfare organizations. Animal welfare organization for for making a provision of feeding and looking after the welfare of stray dogs. Correct?
Yes, sir.
Paragraph. The full stop, learned counsel for GHMC shall apprise this court with regard to the steps taken by GHMC as well as GHMC for feeding and looking after the welfare of stray dogs in the city of Hyderabad in association with what animal welfare
Animal welfare
organizations. In addition, petitioner shall also, the council shall also apprise this court with regard to total number of dogs. As per the total number of dogs shall also apprise about the number of dogs which are yet to be sterilized and vaccinated as per the record of GHMC.
Yes.
List after 6 weeks.
My lord, I appear for the petitioner. My lord, this is a case regarding the distribution of title deeds under the Forest Rights Act.
Both these matters, my lord, we have filed counters, my lord.
And we have not been served with any counters, my lord.
Not served?
No, my lord.
Item number 10, in bill number 10. Today, my lord, we are filing counter. Your lordship may please to take up this matter.
That's the reason, right?
Yes, my lord.
Learned Additional Advocate General, right?
Yes.
Submits that he shall file a counter on behalf of official respondents during the course of the day. Learned in view of aforesaid, he has already filed DSGI. So, learned counsel for the petitioner, in view of aforesaid, learned counsel for the petitioner prays for adjournment to enable him to go through the same and to file a reply to the counter if so advised.
Any short date, my lord?
After 2 weeks, list after 2 weeks.
I'm appearing on behalf of Wellers, I will file counter within 2 weeks.
See,
My lord, in
delete
fact,
this.
There's an
Delete.
implication supposed to be.
Then why one by one, Mr. Mr. Prabhakar, learned counsel for
Wellers has respond number 8.
respond number
I
8.
believe the implied
Implicit petition for 8, my lord. Respond number 8.
He is appearing for 8.
Appeal 7.
I am 10.
We are taking about 10, Mr. 10, you are not party. Then this order stands in 10. The 75, what we have dictated. He says counter shall be filed during additional, sorry, just now dictated, madam. Just now dictated that he shall file during course of day in view of aforesaid petitioner prays for adjournment to enable him to go and file reply if so advised. List after 2 weeks. Say in the beginning, petition is admitted for hearing. Item number 76 is.
We have already filed counter.
Then who wants Mr. Prabhakar?
Implicit
Learned counsel for.
He needs to.
No, you don't need to file.
PIL number 7, Milad.
Which responded?
Respond number 8.
Learned counsel for respondent number 8, Mr. Prabhakar. Praise fund is granted, admitted for hearing. Mr. Prabhakar, praise fund is granted 2 weeks time to enable him to file count.
I filed implicit petition, my lord, in 7.
It shall be considered at the time of hearing.
No place.
You can't be granted any relief in this PIL. You are opposing him, no?
Yes, my lord.
But Mr. Prabhakar alone is sufficient to handle. We wonder whether he needs your assistance. All right. 2 weeks. 2 weeks.
The third respondent had filed counter, my lord. GHMC filed.
Third respondent.
GHMC filed its counter, my lord. Compensation of 8 lakhs is granted to the.
Same like the straight dogs.
This is the regarding the unfortunate incident, my lord. Small boy was mauled by.
Yes. Yes. Oh, sorry. No, but one case we think item number just now we
70. Yes.
70.
74, my lord.
We should take up. What happened?
Yes, in fact, this Honorable Court was pleased to direct the member secretary, Telangana Legal Service Authority to visit the animal care centers and file a report. Report has also been filed by the authority.
Learned DSGI, praise fund is granted. 2 weeks time to enable him to file counter. List this petition along with WP number
74, bill number 93 of 2022.
93 of 22.
Registry to print the name of DGA.
Registry to print the name of DSCI.
I picked up your petitions.
Final hearing.
Yes.
So you can wait for this. We have this thing, Bar Council, a council for Telangana State Bar Council waiting to welcome new members. Subject to result of the writ petition, they are suffering financial loss on account every day on account of non-registration. Their non-registration, as they have not passed the examination in what role? Regular mode.
Enrollment dispute.
Enrollment dispute. So you can wait or
Yes, maybe put to.
you will wait. We'll take it up after that bunch. This case.
Maybe lots. Have you done some other day?
Some other day.
After lunch.
1 minute. Fourth September. We have a chart, so like 4th September.
Entry mod needs to be extended.
Mark the presence of learned senior counsels. Entry mod granted on earlier occasion shall continue. List on 4th September 23.
A very short point arise for your kind consideration.
What is it?
So that we have a development agreement. Under that, my lord, arbitration clause is there. Because of the disputes, my lord, my client has invoked the arbitration clause, went before arbitration. A 3-member arbitration tribunal was constituted. My lord, respondent has, the present petitioner has filed a objection saying that the dispute is not arbitrable as per the law prevailing as on that day. And so, my lord, accordingly, arbitration was closed. And it was recorded that I will pursue alternative remedies. Then I went out of the arbitration, filed a civil suit. Now, my lord, another counter is filed, Section 8 petition is filed, saying that as per the present law, arbitration is maintainable and this civil suit is not maintainable.
The law, they were not what I can't welfare.
So as
the law has changed. I have
2016, my lord, once again.
Earlier, the division bench of this court, I said that it's not an arbitrable dispute. That's the objection they withdrew it. It's not that they withdrew it. Subsequently, by the virtual judgment of Honorable Supreme Court Deccan papers, it said it's arbitrable. So I filed Section 8 application. So, it can't be estoppel against the law. Like now, law later.
One of the questions is whether they can turn around and my lord,
Yes, sir. Can't be estoppel against the law.
That we will appreciate.
can be a estoppel, whether there can be a estoppel by conduct, whatever.
Yes, by conduct so. Yes. So it may not take much force.
Interesting proposition.
Yes.
But his predicament you will appreciate, right?
The Lordship may also appreciate my I'm what will I do?
You will have to decide it on merits. No, nothing, no other option. But
yes,
he has put it so simply, right? This
no, that's all the facts, my lord.
Making the complicated issues look simple is the art of advocacy.
Yes. To that extent, I find
what is the law in that? That's except that
Yes,
what is the law applicable?
to cut short the court time, my lord,
Yes.
synopsis also all that.
Yes. Thank you.
Obliged.
4th September.
Thank
17. Acha, all three together.
Millet, I am appearing for the state millet. They are challenging millet. They are para 7 of
Madam, 81 to 96 probably. 85.
81 to 89.
Somebody. The list shows 96. What is 81 to 96, correct?
81 to 96 to 80.
96, madam.
I am appearing in 81.
Whatever. So there are incomplete petitions, something like that.
The challenge is late. The presidential order, paragraph 7 million.
Item number 81, amendment petition, what do you say? Mister, what do you say? Amendment?
It can be amended.
Mark the presence heard on the question of admission. Petition is admitted for hearing. Heard on IA number 3 of 2022, taking into account the nature of proposed amendment and for the reasons stated therein, same is allowed. Let amendment be incorporated within 2 weeks and an amended petition be filed within the same time. Now, what you want to file counter?
I want to file my counter, my lord.
Paragraph. In this writ petition, the petitioner has impugned the validity of GOs
124.
GOs dated 30th August 2008.
Yes.
And 26/4/2022, by which reservation in the category of deputy collector and equivalent categories has, to the extent of 15%, 95% has been prescribed in favor of local candidates, right?
Yes.
Learned counsel for respondents prays for and is granted 4 weeks time.
Yes.
To enable him to file counter to the writ petitions, counter to the petition, right? Then 90, 95 and 96, you madam, same, right? Same thing. This petition has challenged GOMS, whatever. You have also challenged same thing, 2 orders. Then learned counsel heard on IA number 1 of 2 of 23, whom you want to implead? Mr. Praveen Kumar, happy with impleadment? No. Happy? You must be happy, right? Not opposing. Heard on IA number 2 of 23 after hearing learned counsel for the petitioner, Mr. Praveen Kumar, DSGI. Same is allowed. Let amend cost title be amended and then issue this same, right? Issue involved in this petition is same. Learned DSGI and you are GP for?
I'm the special GP for the state government.
Special pray for and are granted 4 weeks time to enable them to fight counter. Implead in this also 96 also, madam. Same order in 96. Implead 4 weeks time to file counter. Yes. 97, 98.
Yes, my lords. In this, my lord, on the last occasion, lordship was pleased to grant 2 months time for establishment of State Security Commission as well as the state level police complaint authorities and
what you are not doing it?
my lord, request for that time. I received a letter from the principal secretary, my lord, requesting another 4 weeks time. But committees have been constituted, my lord. Buildings were allotted, except ministerial staff, my lord.
No. So have these committees made functional?
Yes, my lord.
By providing office staff.
Office has been allotted, building has been allotted.
Committees have been
Constituted.
Yes, mark the presence. In this public interest litigation, the issue pertains to formation of State Police Complaints Authority and District Police Complaints Committee in 2 regions, namely Hyderabad region and Warangal region, and making the aforesaid 2 committees functional. Paragraph. Learned counsel for the your government GP for whom on instruction submits that after that in pursuance of the order dated 23/6 to 23/6 to 2023, 23/6/2023, the whatever the State Police Complaints Authority and District Police Complaints Authority have been constituted and office space has also been allotted to them. It is further submitted that the process of recruitment of
ministerial staff
has been initiated.
It has been initiated
for recruitment of the ministerial staff for making the committee functional has been initiated, and the same shall be completed within
4 weeks.
4 weeks from now, today. The line below, in view of aforesaid submission, the
Accounts member is not appointed.
1 minute.
Sorry.
So vacancies in this thing, yes. Telangana Value Added Tax Tribunal.
Well, the tribunal is as
Functional.
It is functioning, there is one chairman and one departmental member,
Since when?
Since January 2023, his grievance was the departmental member, went on leave so that tribunal could not function.
So the grievance does not survive.
No.
Yes. Madam, right. This public interest litigation was registered on the receipt of a communication from the President of National Association of Tax Professionals, in which about stating that for a long time post of accounts member as well as post of departmental member in Telangana Value Added Tax Appellate Tribunal are lying vacant. Full stop. Paragraph. A bench of this court took cognizance of the communication and issued notices to respondents on 23/1/2023. Paragraph. Learned Counsel for Respondent. Number 3. Learned Counsel for Standing Counsel for Commercial Tax Department.
Yes.
Learned Counsel for Commercial Tax Department on the basis of instructions submit that since January.
April, the departmental member, his case was the departmental member went on leave, so the
No.
could not function.
Grievance is that the post of accounts member and departmental member are lying vacant.
May I read, Recently, the learned departmental member went on leave.
This will be short.
But it can function with one appointed member or the chair.
It is lying vacant, he says.
No, departmental member has been appointed.
When departmental member appointed, Mr.
To join back.
She was appointed, much earlier. She went on leave. During the limited period, she was not available.
When she joined?
April 23, Since April 23, the tribunal is functioning,
Learned Counsel for the Commercial Tax Department submits that in fact departmental member of the Telangana Value Added Tax Appellate Tribunal proceeded on leave, long leave. However, the aforesaid departmental member has joined in when? On
April
is 30
April
days.
23,
30 days. Has joined in April 2023, and since and from the date of her joining, the Telangana Value Added Tribunal, Value Added Tax Appellate Tribunal is functional, and but functional as it can function with chairman and one member. So what about accounts member? You don't want to fill up?
No. What happened, accounts member, he has to be, from the Indian Revenue Service. Not
We
below the rank.
hope and trust that the post of judicial member, accounts member in the tribunal shall also be filled up expeditiously. Since the grievance of the appellant is substantially redressed and the tribunal is functioning since April 2023. Therefore, we are not inclined to proceed further with this petition. Accordingly, same is disposed of.
What's up?
Then what happens to 100? Same. No, writ, they may have filed, they will say that we can see. 100.
It's connected.
Writ. Mr. In writ, there may be a direction to fill up the post. To that extent, it may survive, right? Don't get it like disposed of. So you file. What's the prayer?
Whereas the means 20.
All right, so in the, Mr. 21, what is the prayer?
Lord, to appointment of post of departmental member.
Ad hoc arrangement.
Page 13.
Ad hoc arrangement to departmental member. Learn it. So when it was appointed, in this petition, comma, the petitioner has made a prayer for appointment to the post of departmental member under section 3 of the Telangana VAT Act 2005. Learn it council for commercial tax department on instruction submit that the departmental member has been appointed, has already been appointed, and the departmental member is functioning since April 2020-23. Therefore, line below, therefore, it is evident that that the grievance of the petitioner stands redressed. The petition is accordingly disposed of. Which passover matter, madam? This LLB batch. That's it. 51 to
59 on
59 to 60. So, Mr. 230, Mr. Today it seems to be the day for them. Correct. He will hear. But is it really so urgent? What, any respite to them by you? No.
I'm sorry, Willard.
No, Mr. You had, we had an occasion to see the chart. I mean, last date of hearing. So probably you have said that regular mode. So are they entitled?
But
The only issue is that they have not passed +2 examination in regular mode.
As far as
Therefore, you say that they are not entitled for enrollment, correct?
Willard, the entire batch
So
of
we are not hearing finally.
I'm only making one submission.
We 230. We just wanted to know what is your this. What is the what have you found out after preparation of chart?
What I have found out after
None of them is eligible.
No, what I have found out after the preparation of the chart is that except two petitioners, all the others have 10th standard and intermediate by regular study. They merely do not have the degree graduation by regular.
They do not have degree?
It's the graduation course by regular mode.
By going to college, it is all distance education.
Graduation mode?
No, graduation by regular mode. There are other applicants who are about 40 applicants who do not have 10 and +2, but none of the petitioners fall in that except two.
Let's see. Let them come.
Very well.
Yes. Who? What? Call.
The petitioner appeared the NEET PG 2023, my lord. She secured rank 76,427. Made an
How much?
76,427. Made an application under management quota, my lord.
427. Management quota.
What? By oversight, my lord, she did not put the tick on the NRI quota, my lord. Now seeking.
You want admission in NRI? You make a representation to Mr. Rao, he will consider.
Despite the NEET PG 2023, my lord.
Right.
She secured rank 76,427.
But university is considering under NRI also.
How much? NRI.
76,427.
Decide it or?
Made an application under management quota.
Decided.
427. Decide management. You are sufficient.
By oversight, my
That
lord,
since
she
he has applied under
did not
management
put the
quota,
tick
therefore
on
his
the
case
NRI
for
quota, my lord. Now
NRI
seeking.
quota admission in NRI. You make a representation to Mr. Rao, he will consider. Mark the
Despite
presence.
the NEET PG 2023, my lord. She secured rank
Petitioner
76,427.
University is considering under NRI also.
How much? NRI.
76,427.
Decide it or?
Made an application under management quota.
University. Management. You are sufficient. Allot.
By oversight, my lord,
Since he has applied under
did not put
management
the
quota,
tick
therefore
on
his
the
case
NRI
for
quota, my lord. Now
NRI
seeking.
quota admission in NRI. You make a representation to Mr. Rao, he will consider. Mark the
Despite the
academic
NEET
year
PG
23.
2023, my lord.
Paragraph.
She secured rank
Tax giving
But
$76,427.
university is considering under NRI also.
Decide it or?
Made an application under management quota.
University. Management. You are supposed to allot.
By oversight, my lord,
Since he has applied under
did not put the
management
tick
quota,
on
therefore
the
his case
NRI
for
quota, my lord. Now
NRI
seeking.
quota admission in NRI. You make a representation to Mr. Rao, he will consider. Mark the academic year
PG
23.
2023, my lord. She secured rank
Tax giving
But university is considering under NRI also.
76,427.
Decide it or?
Made an application under management quota.
Management. You are supposed to allot. Since he has applied under management quota, therefore his case for NRI quota admission in NRI. You make a representation to Mr. Rao, he will consider. Mark the academic year 23. What do you want? Management quota.
Sorry. The petitioner last academic year she got an admission in the PDS. Now this academic year she got MBBS seat. So the results, the allotments are made yesterday. So meanwhile there is a difficult to collect the original certificates from the earlier college to now to college. So I am praying that to the MBBS, the medical college may take the admission without insisting for the original certificate. So meanwhile, I will collect the certificate. Matter is covered by the petitioner last academic year she got an admission in the previous
time frame.
So now this academic year she got MBBS seat.
Publishing original certificate, she may be admitted as per
allotments are made yesterday.
eligibility
So
and
meanwhile,
merit.
there is a difficult to collect the original certificates from
Will
the
you do
earlier
it
college
or
to
we die?
now to college.
So
So I am praying
has
that
to allot it to a college. College people, yes, the
medical college may
college
take admission without insisting on the
respondent
matter is covered by the last academic year she got a admission in the previous year. Now this academic year she got MBBS seat. So the allotments are made yesterday. So even it is really difficult to collect the original certificates from the earlier college to now to collect. And trying us to without MBBS, the medical college may take admission without insisting on the respondent. Matter is covered by the last academic year she got a admission in the previous year. Now this academic year she got MBBS seat. So the allotments are made yesterday. Even it is really difficult to collect the original certificates from the earlier college to now to collect. And trying us to without MBBS, the medical college may take admission without insisting on the respondent. Last academic year she got a admission in the previous year. Now this academic year she got MBBS seat. So the allotments are made yesterday. Even it is really difficult to collect the original certificates from the earlier college to now to collect. And trying us to without MBBS, the medical college may take admission without insisting on the
So lunch motions are over, no? Yes. Legal education. So lunch motions are over, no? Yes. Legal education. Password. Mr. How much time?
Said the statement about
No, we are asking you how much time, not more than 10 minutes. So lunch motions are over, no? Yes. This all, we have heard it at length of previous occasion. Legal education. Yes.
I may be permitted to pass on the synopsis.
Please. Yes. Mr. How much time?
said the statement about
No, we are asking you how much time, not more than 10 minutes. So lunch motions are over, no? Yes. This all, we have heard it at length of previous occasion. Legal education. Yes.
I may be permitted to pass on the synopsis.
Please. Yes. Mr. How much time? No, he submitted that. No, we are asking you how much time, not more than 10 minutes. So lunch motions are over, no? Yes. What have you submitted, please? Yes. 10 plus 2 in
I may
regular
be
mode.
permitted to pass on the synopsis. The requirement for admission to the law course, either 3 years or 5 years, is governed by Rule
Mr.
5
How
of
much
the
time?
legal education rules.
Correct. What statement? Banking upon your admission, which is not in. No, we are asking you how much time, not more than 10 minutes. So lunch motions are over.
There are 3 levels, 10th standard, the matriculation.
What have you
12th
submitted,
standard,
please?
the senior
Yes.
secondary.
10 plus 2 in
I may
regular
be
mode.
permitted to pass on the synopsis. The requirement for admission to the graduation of the degree, either 3 years or 5 years,
Yes.
is governed by Rule
Mr.
5
How
of
much
the
time?
controversial rules.
He shall argue, right? Statement you will argue. Banking upon your admission, which is not in. No, we are asking you how much time, not more than 10 minutes. So lunch motions are over.
There are 3 levels, 10th standard,
We
the
are, he is
matriculation.
arguing. What have you
12th
submitted,
standard,
please?
the senior
Yes.
secondary.
10 plus 2 in
I may
regular
be
mode.
permitted to pass on the synopsis. The requirement for admission to the graduation of the degree, either 3 years or 5 years,
Yes.
is governed by Rule
Mr.
5
How
of
much
the
time?
controversial
He
rules.
shall argue, right? Statement you will argue. Banking upon your admission, which is not in. No, we are asking you how much time, not more than 10 minutes. So lunch motions are over.
There are 3 levels, 10th standard,
We are,
the
he is arguing
matriculation.
What have you
12th
submitted,
standard,
please?
the senior
Yes.
secondary.
10 plus 2 in
I may
regular
be
mode.
permitted to pass on the synopsis. The requirement for admission to the graduation of the degree, either 3 years or 5 years,
Yes.
is governed by Rule
Mr.
5
How
of
much
the
time?
controversial rules.
Argue, right? Statement you will argue. Banking upon your admission, which is not in. No, we are asking you how much time, not more than 10 minutes. So lunch motions are over.
There are 3 levels, 10th standard, the
He is arguing.
matriculation.
Request is to
What have you
submitted,
submitted,
please?
senior
Yes.
secondary?
10 plus 2 in
I may
regular
be
mode.
permitted to pass on the synopsis. The requirement for admission to the graduation of the degree, either 3 years or 5
Please
years,
give us some facts.
is governed by
Mr. How much time?
controversial rules.
He is arguing. Banking upon your admission, which is not in. No, we are asking you how much time, not more than 10 minutes. So lunch motions are over.
There are 3 levels, 10th standard, the
He is
matriculation.
arguing. Request is what have you submitted, please? Yes. 10 plus 2 in regular mode.
Pass of the synopsis. The requirement for admission to the graduation of the degree, either 3 years or 5
Please
years,
give us some facts.
is governed by
Mr. How much time?
controversial rules.
Banking upon your admission, which is not in. No, we are asking you how much time, not more than 10 minutes. So lunch motions are over.
There are 3 levels, 10th standard, the
He is arguing. Request is what have you submitted, please? Yes. 10 plus 2 in regular mode.
Pass of the synopsis. The requirement for admission to the graduation of the degree, either 3 years or 5
Please
years,
give us some facts.
is governed by
Mr.
how much time? We are asking you how much time, not more than 10 minutes, once the questions are over. There are 3 levels, but no, interesting. Please give us some how much time? We are asking you how much time, not more than 10 minutes, once the questions are over. There are 3 levels, but Please give us some how much time? We are asking you how much time, not more than 10 minutes, once the questions are over. There are 3 levels, but
recognizes the
Challenge the validity, no.
But we have challenge route 5.
Not challenge, no.
Please see the prayer.
Prayer. In the petition, we have WP 45880. There is no prayer that rule be declared ultra virus.
They say, violation of the provisions of the Advocates Act 1961 is under challenge.
No, under the circumstances. Read. Prayer clause.
Yes. No disturb date.
No, this is prayer in other petition, madam. 45880. This is the prayer.
This is the prayer, page number
11. Okay, I'm looking something else. Prayer. So challenge is not made to validity of rule.
Well, in fact, the rule 5, there's a proviso.
No.
Which helps me.
Hey, we want to understand,
Yes.
Mr. Say so, I have not challenged. And my case is that
Yes.
on a particular interpretation,
not-
I
bench of this honorable court in that writ appeal. But as far as the question of equivalence is concerned, the letter of equivalence granted by the UGC at page 44 in the same file.
Yes.
Lord, this is the distinction that is sought to be drawn. May I read this letter, Lord? The second paragraph of that thick notice. Equivalence of qualification acquired through conventional or open and distance learning and online modes. Degrees at undergraduate and postgraduate level in conformity with UGC notification on specification of degrees 2004. Any degree that is awarded under this specification itself qualifies for this equivalence, even according to this public notice. And secondly, Lord, the rules for standards of education and for enrollment are the Council of India rules, and this, in my respectful submission, would not be of relevance. But those are my submission.
What flows from the chart which you have given?
Lord, the chart is showing, except two petitioners, all the others have completed their 10th in the regular mode, +2 in the regular mode, and everybody has completed their degree through open university or distance education only.
So which two have not opted? Except two means which two?
One was a case where there was
WP petitioner number so and so or WP
I'm
number.
pointing out. Petitioner number 7 in WP 46145 in that tabulation 46145 of 2022.
And second petitioner in
The second is 45880 minute.
petitioner
In 45880 of 2022.
45880.
There is a sole petitioner in that.
Of which year?
2022. 202.
Yes. Now, these people have done what? First petitioner number 7 has done what?
Petitioner number 7 in WP
We have got it. Yes. What he has done?
Has completed intermediate through Open School Society.
Open school and then
graduation in the Open University.
Graduation also in open.
Not all the petitioners have done their graduation.
So graduation and then
that is as far as
graduation in open. And second, the petitioner in second petition,
he has done his diploma in electrical and electronics engineering in place of intermediate. After his 10th standard, he pursued his diploma course.
Diploma through distance?
No, the diploma in the regular mode.
And then?
That's all. He pursued BA in the Open University.
And thereafter LLB?
Law in the SS is regular.
And then law in regular mode?
All the petitioners have pursued law in their regular course. All the petitioners have pursued their degree in the...
No, but this thing, then petitioner in WP 45880, you say 10th also he did it in regular.
No, but he did regular. He did, instead of intermediate, he did his diploma.
So diploma also regular mode?
Yes.
And then law also regular mode?
The degree which preceded the law by Open University.
So that you didn't tell. Degree? Degree?
He did his BA in Open University.
BA, okay. All right.
Lord, All the petitioners have done their degree, that is the 3-year degree course by Open University or distance education only.
Yes, okay, yes. All right, thank you. But for your assistance, ask.
Six, serial number 6.
Serial number 5, my lord.
6. Some William Carey University.
My lord, this William Carey University is one course that he says he has done. He has enclosed DSC from Madurai Kamaraj University. also.
Distance.
This also is.
No, but William Carey, is it not a regular university?
My lord, William Carey University, according to the petitioner himself, he is not certain whether it exists in reality, whether it exists only on paper. He himself has addressed a letter saying, my university is not sending messages, not responding to my calls. This William Carey University is supposed to be in Meghalaya or Sikkim, the northeastern state. The petitioner himself in his affidavit avers categorically that they are not responding to my calls, they are making unreasonable demands, etc. Therefore, he doesn't want to rely on that and he wants to rely on the DSC of the Madurai Kamaraj University.
Okay. That's it, Mr. Anything else? All right, yes, Mr. Senior Counsel. 1 minute, we'll hear you. So let Senior Counsel this thing submit rejoinder.
Lord, kindly see, well, the judgment of this honorable court, division bench, Lord, what my friend tried to read in between the lines. Para 11.
So, division bench does not apply.
Not with the Malad.
What is the submission?
Malad, this judgment is pertaining to a candidate whose degree was recognized by the university as equivalent to degree, not by University Grants Commission. But we are
Division bench pertains to a candidate.
Para 11. Yes.
No, candidate what?
Candidate into admission into LLB course.
So whose degree was done what?
The judgment was basing on a candidate with a degree, according to him, is equivalent of a regular degree recognized by the same university. Whereas we stand on a different foot. Our degree courses, distance education degree courses, are recognized by UGC. Therefore, the judgment
Therefore, judgment of
does
DP does not apply.
Yes, sir, does not come in our way for seeking enrollment.
All right.
And para 11 is the Malad.
We will read it.
Yes.
Again, we are reiterating same thing.
Yes.
Again, any other next submission?
Yes, ma'am. Once this goes, Malad, there is nothing Malad from the side of the council to oppose our enrollment.
All right. So we will read para 11 now.
Yes.
Yes.
The certificate issued. The certificate issued by the Usmania University reflects that university has certified that BA external examinations conducted by the Usmania University examinations are equivalent to BA 10+2+3 pattern, meaning thereby the university is declaring its own degree of BA external equivalent to BA regular.
This is important. No power to declare its degree as.
But if an university declares by itself, but whereas in our case, UGC had recognized.
Correct.
And the universities are established by the Act of Parliament or state.
All right.
That's all.
Thank you. Yes, madam.
So then, the one more judgment, Millard, which I have filed, Millard, along with my material papers, at page number 89. This is the Millard judgment of Honorable Supreme Court. Single page judgment, Millard. That is Millard, the third paragraph from the bottom.
So, what is the judgment about? You first tell us.
See, Millard, with regard to the equivalency one. That is Millard, the candidate also.
They are not saying that it's not.
Say
Madam, don't harbor on a point which is not pleaded by them. They are not saying that degree obtained by you is not equivalent. I'm not saying that.
But we are not there. The contention of the bar council is that Miller.
No
It
contention.
should not be considered. That is the Miller their stand.
Explain it to madam that what you have argued once again. Your stand is that, madam, their stand is you have not done in regular mode. That's the objection. So this is no question of equivalence. They are not disputing. Don't open a third front which is not this thing. Don't fight on which is not opened by them. They are not saying not equivalent.
That is judgment of.
He has said no.
Other Miller with regard to the rule making powers of bar council Miller and judgment of honorable.
Not challenged. Rule making power is not challenged. Have you challenged that bar council has no power?
But Miller, the bar council is having the right to Miller.
They don't have right to make rules. This is your
Honorable Supreme Court said Miller.
don't have right.
That is what honorable.
No. Hey, what it says, you must tell, madam, you are appearing here as an officer of the court, not giving us this thing, results to solve. You should tell us what passing on the buck like this. We will say that without such this thing, it has been passed on, which is discarded. What does it say? That Bar Council of India has no power to frame rules.
That is Miller.
1 minute. Where is in your writ petition you have pleaded that Bar Council has no power to frame rule? Which paragraph?
Because Miller, we have not pleaded that.
In your cases, madam, your cases de-linked and it will be heard separately. All other cases we will pass an order. You want to amend the petition? You want to amend?
My petition is Miller.
No. Madam, orally just like this you cannot argue. There has to be a pleading. He has to be given an opportunity to meet it. You cannot say orally that they have no power, this thing, nothing. Where is it pleaded in the writ petition? Which paragraph that Bar Council of India has no power to frame rules?
But of course, Miller, we have not pleaded. But Miller,
the matter.
during argument,
Thank you.
less than the same.
You will have to, in case you want to rely on the Supreme Court and say Bar Council has no power, amend your petition. We will de-link it and grant you opportunity to amend.
Not like that, Miller. Let it be. It need not be deleted. But Miller, where my Lenfant has taken the plea during arguments, I have minutes.
No, he has not taken argument. He said, see, mister, how? You want to amend it or not, madam?
Need not do.
Need not amend. And then end of the matter.
Subject to your lordship's leave, Miller, the Honorable Supreme Court as late as in June 2023 has
all half-hearted issue doesn't want to amend it, so we cannot go into it. Had he amended, we would have decided. Now you give.
I'll just pass on for the sake of.
He has power. Who can say that our council has no power to frame rules? Arguing contrary to what can we do, madam, mister? That's it. Thank you. Mark everybody's presence.
Subject to your lordship.
Arguments heard. Judgment. Case reserved for delivery of judgment. Thank you. Thank you.
Subject to your lordship.
Oh, it was a long wait for you people because of MBBS candidates, right?
I'll be failing in my duty, Milord, if I do not bring to your lordship's notice one fact. Milord, there are a few judgments by learned single judges of various high courts, which are to the effect that state that people who pursue open university do so because of various circumstances and they should be treated on par.
Give those judgments. We would like to see the reasoning. Please pass it on. It has been reserved. You can pass on after.
Very well. Your lordship may grant me some time because
some time we want.
Your lordship may reserve the matter.
Reserved. We have reserved the matter.
I will.
We have reserved the matter. You file at the earliest Monday.
Very well.
Hand it over to the court master.
I'll do so.
Thank you.
I am deeply obliged.
Yes. Yes, madam. For.
My lordship. My lordship.
Yes.
Right.
Ah, yes.
Appeal is quite challenging the
Lordship.
single judge's
My
order.
lordship, may I request, my lord?
Directing
My
the
lord,
repayment of
representing on behalf of council for respondent number 1, my lord, N. Vijay. He is unwell, my lord. He is suffering with viral fever, my lord. Request 1 week time, my lordship.
Learned counsel for respondent, Mr. So and so prays for adjournment on the ground that the arguing counsel is unwell. List after 1 week.
May I request the second week of
Second week.
after 10th September.
September. All right. List after 2 weeks. Correct? That should be fine. Yes.
I have placed, all the three appeals. Agreed by, one single judge, order, pertaining to, the tender allocation. The unsuccessful bidder, file a repetition. Unsuccessful bidder. File a repetition. But the repetition was allowed, setting aside the order of allocation. But did not grant any favor of either unsuccessful bidder or ASI or the nominate third appellate. For all the parties are before the lordship. I have not the interpiece. Last occasion there was interim order passed by the General Court.
Fresh tender.
Yes.
The liberty has been granted.
Now it is not on nomination basis. Almost 80% has been work has been completed. Last occasion there were interim stays have been granted by the General Court.
You are the one of the appellants.
I am the ASI, Virat. I am the
What appellants?
No, I am the second. I am the appellant.
Which appeal?
Second in the third appeal.
103 822 822.
Yes. In 822 minutes there is the interim order. It was heard elaborately. And last
Amalettes, I am the appellant in 781. That's the item number 102. And my lords, my arguments.
780.
Yes.
780.
780. My contentions and arguments are in the present case are entirely within the parameters of the law laid down by the Honorable Supreme Court of India in Tata Cell, my lords, where I am challenging.
Who is the appellant in third appeal?
Third appeal,
Who is there?
And for the,
on both ways,
appellant in item number 104, my lord, the counsel on record is not currently unavailable due to personal emergency matter. The matter may be
That's
adjourned
why
to
we were
any shorter
asking who
date,
is
my lord.
not the appellant. He should have ideally said in the sit down, mister. Don't stand.
Appellant in item number 104.
So what do you want? These two people, senior counsel and they are ready to argue.
I am ready to argue.
For the 820. Last may fix a date, Virat, with the since your pleadings are completed.
Date may be
My lords, I date fixing a date is not an issue, my lord. But only thing is, I just want to say that the statement given by the DSG
So
just
we are not influenced by anything, right? We have not.
sure, my lords.
We have not even got any notes.
29th, my lord said.
Any
29th.
shorter date may be fixed, my lord.
29th.
Any date convenient to the court may be fixed, my lord.
So it's convenient for us today. Don't Mr. pass on the buck by seeking adjournment and telling that if today's date is inconvenient. Don't like, you are seeking an adjournment today. It's convenient for us to hear and decide it right away. Right? Don't say that's convenient.
There is interim order.
Praveen Kumar, please prepare a synopsis of
Right,
that. Like, we will know, we can't give it 2 hours to hear this happened, that happened. Give us where contract awarded, what happened, what ground, single judge, what is your submission? 2 page.
Very good.
In a matter of admission, council prepared short synopsis, short
5
notes,
pages, sir.
5 pages, you know.
Okay.
Don't do it like this.
No, I prepare short report.
In your appeal, 2 pages and everything, case law, everything, paragraph.
Right.
At a glance, we should be ready.
Right. Second appeal, I find impeded. But it is not a party before the. I find impeded.
We consider it at the time of hearing. We are not, we are only fixing a date, right? He is praying for adjournment. You didn't hear? You heard him.
Yes, I had. Yes,
Well, September. List on learned. You are learned counsel for the appellant in item 104. Huh? W.
Date sheet.
Yes. See, all 2022 matters.
On the last occasion, my lord, they filed a additional affidavit, my lord. Appearing on behalf of the state, my lord. I am appearing for the petitioner. On the last occasion, my lord, the state.
Mr. Prabhakar, you are not appearing for petition.
By supporting
No, no, you are-
contentions of the petition.
You are not appearing for petitioner. He is appearing in a place reserved for respondent and saying, so normally you appear for petitioners, right?
I am also supporting the petitioner contentions.
During the course of arguments, my lord, this court pleased us to file an additional counter, for which we have filed additional counter. At last occasion, they took time to file a reply to the additional counter filed by us.
On the last occasion, my lord, they filed the additional affidavit. And immediately, my lord, we have served, my lord, them notice as required under rule 15 of the writ proceeding rules to submit the documents, permit us to inspect and furnish the documents referred to in the counter. And we also served a notice under Article 12.
We are not concerned. Do you want time to file reply or you don't want?
Yes, my lord, I will. I want.
Say so.
No, but I also filed IAS, my lord, at short my submission. IAS, I filed direction to them, my lord, to submit the
Incomplete petition, etc. Everything is pending.
No, not
It is incomplete.
1 and 2, 2023, my lords.
No. What is incomplete petition?
So, incomplete petitions, my lord, so far as incomplete petitions are concerned, my members, society members sought to include, and which, my lord, we have submitted in view of the Supreme.
What do you say, Mr. Everybody, with regard to incomplete petition?
No,
objection.
No, we have objected, my lord, in view of the Supreme Court judgment Constitution bench. Query society independently member
Yes,
cannot.
madam, right. IA number
1 and 2.
IA number 1 of 22, 2 of 22, 3 of 22, 4 of 22, as well as 5 of 22, 5 and 6 of 22. IAs 1 to 6 of 1, 3 to 6 of 22, right? 1, 2 is not there, right? 1, 3 to 6, 3, 4, 5, 6, right? Of 22 shall be considered at the time of hearing of the petition. Learned counsel for the petitioner, raise warrant is granted. How much time?
But for reply, my lord. But this you last may consider, my lord, 1 of 2023 and 2 of 2023 for a direction to produce the document referred to by them, which is necessary, my lord, for us. I filed applications, my lord.
Let them approach the authorities. If the authorities refuses to furnish.
We have approached
right to information.
We have filed the renewals also, they are not furnishing.
Appeal.
But now, my lord,
The writ rules, whatever they are relying on in the counter. They are relying on.
We have filed.
They are relying on, they did not file.
1 minute. Strange thing, right? If they have not filed, they can't rely. If they have not, supposing if they are relying on some GOMS, which they have not filed, can it be read?
This is what, Miller, under the rules, I need to seek production.
We don't know, Mr.
No, I need to seek production. If they don't produce, then adverse inference can be drawn. That is what is contemplated.
If they are not filing it, adverse inference will be drawn.
But before that, Miller, direction needs to be given by the court, Miller, in terms of the rules.
1 second.
Which rule?
In the writ affidavit.
Which rule?
But I filed in rules 15, in terms of the writ rule 15 and order 12 rule.
No, even though they are not relying on anything, you will still seek a direction to produce documents. So conduct fishing and roving inquiry in
Whatever they are relying on in their counter, they
not relying, mister. If they have not annexed the documents, how can they rely?
are relying on, Miller. Their contention. Their contention they have issued is what, Miller. Therefore, I am.
Societies, others, so they are seeking us to publish the details of other society, which are nothing to do with this case, my lord.
Don't you think that what do you think we will permit them to produce the documents handed over across at the time of hearing without supply you a copy and dismiss your petition? This is the impression you are gathered. No, no. So if they have not filed the documents, if you rely on something, are you not required to file it before the court? Tell us.
Yes.
They have not filed it. That means not relying. We will have to say that it is no material on record to whatever he may argue, but we will say that there is no material to substantiate it by this. You should say that argument when it is heard, instead of you are putting them on notice, and additional advocate general today itself will guide them that you file document and supply a copy to them. This objection should have been, you don't understand. Everything like ask the court will give you an advice what to do. Huh?
No, not like that. This is it is a matter remanded by the Honorable Supreme Court.
No, so
on the ground.
It remains a matter for us to be decided.
I am not saying that. But the discrimination ground was this Honorable Court.
We don't understand, Mr. Learned does not want to argue this.
Monday,
this is for final hearing, argue.
No, Monday.
You don't want to file a reply. No, if we are nice to you, you don't understand. Argue.
I'll file reply on Monday, your lordship.
Not Monday.
Any day convenient, your lordship.
No, Mr. Prabhakar, explain to your what is it doing. You don't understand.
I'll serve Millard in the meanwhile and file in the registry, Millard. I thought
Monday at 10:30, right? Huh?
No, any day can be.
No, 9:30 a.m. in the morning for 2 hours. The petitioner prays for and is granted 2 weeks time to enable him to file reply to the additional counter filed additional affidavit filed on behalf of respondents.
Published.
Understand? Thank you, Vishnu. Yes.
Pilots.
Mr. Advocate General, what brings you here?
My lords, in fact, the writ petition per se is, my lords, it's not justiciable. So this is in relation to, my lords, the
All right,
discretionary power.
yes. What is it?
And he's
Huh?
1 week time, my lord. I came on record with that.
1 week time? What have you challenged in the petition?
I seek only 1 week time. My lord.
No, what have you challenged? Will you tell us?
This is the message, my lord. My name has been sent to the,
Huh?
the governor has sent my name twice to the, to appointment as a MLC.
Speak into the mic, please.
My lord, my name, the governor has sent my name to the,
Help him, he is not able to, he is still MLC, right?
my lord, my name has been sent by the governor. Twice, once, not twice it has been sent. And they are not considered because he is having a special knowledge that petitioner has filed several appeals before the Honorable High Court. The considering his experience, the governor is pleased to send my name to the government to appoint me as a MLC. And first time also sent and second time also sent. But the government has appointed who is unqualified person as per section article.
You have served notice on him. Pending, right? But he wants an adjourn.
That's why 1 week time may be given, I will elaborate.
We quite see the prayer clause. That's why he was hesitant not to tell. Learned counsel for the petitioner prays for adjournment to enable him to prepare the case and argue the same. Mark his presence also. You are appearing as
Please, your lordship. I have a two-page land to the extent of two-page synopsis land to the extent of about 1148 acres. 1148 acres is sought to be acquired by the government under separate legislation, specifically governed by
1148
Endowment Act. 1148 acres of land is sought to be acquired.
All right.
Under a separate land acquisition legislation, contrary to the act which governs the religious and charitable institutions. There's an act called the Telangana Charitable and Hindu Religious Institutions and Endowments Act.
So there was a stay here, right? Stay in this writ petition.
Yes, there is no.
There is
no stay here. There's no.
No,
I'm taking the stay below. I'm appearing in
final here.
final.
All right.
I have a two-page synopsis.
No, but you are for the petitioner.
In 107. He is appearing in 108.
There are two cases.
The order of the High Court that you endowment land need to be, one need to approach this High Court for and take permission. How can that be deviated? There is an order of His Lordship Justice, Division Bench of this court, His Lordship Justice.
Your lordships have also been considered in several other cases.
Except for irrigation projects, even there also permission of the court is required.
That's the reason, Millet. I'll make my submissions, Millet, on the merits of the case, Millet. Your lordship may fix any date, Millet. We are ready. Pleadings are complete.
But today is hearing only.
Millet,
Today is also hearing.
Millet, Dilan, the Additional Advocate General, Millet, is leading us in this matter, Millet. I'll request him to be present.
Just now he was here, no?
Yes, Millet. He went to attend, Millet, the at first court, Millet. Your lordship may kindly have it on Monday or Tuesday.
Everything on Monday, you know that is not possible.
Any convenient day.
When this thing always say Monday.
No, any
You know
convenient
it's
day.
not possible.
Any convenient day.
All cases cannot be listed on Monday.
Subject to your lordship's Millet convenience, Millet, any day your lordship may fix it.
Kindly permit us to make our submissions, then we.
What?
Kindly permit us to make our submissions.
We understand that you say that please consider our prayer for stay. That is understandable. Merely because stay is not granted, everything we cannot hear and this thing by at 2:30 in the night deliver judgment today itself. Is it possible? We can understand that you please stay the proceeding till it is heard. That is understandable.
That is sufficient, Your Lordship.
Piecemeal hearing that today we will forget by next date. He is praying for adjournment, right? Do they not accommodate you when you
Great,
seek
yeah.
adjournment?
Great.
So please, it's between you and him.
We are in
You have
that
given-
hands, Your Lordship.
No, you have given the list of dates. He can. All right, you argue he doesn't want an adjournment. He is opposing the prayer for adjournment. Correct. What can be done?
The counters and the replies were filed
Right.
long back. Your Lordship. The
Long
count,
back, so therefore it is listed for this thing.
Your Lordship,
He is opposing the prayer for adjournment. What can be done? You talk to him. He is opposing the prayer. He said, I may be heard just now. Senior counsel is more this thing gracious. He didn't say anything. But the other one is not opposing. He is opposing prayer for adjournment. What can we do? We have to hear his case. We will adjourn his case. Hear his case today. And you argue in that case, his case, item number.
that both are connected with similar and identical matters.
What can be done, Mr.? What can we do? He is opposing the prayer. We will have to adjudicate this whether adjournment has to be granted or not.
Yes.
Right?
No, we are in your hands, Your Lordship. If your Lordship prefer to adjourn, I am fine with it.
What is the normal rule? If you are not well, then also we will then next your case, we will ask him to note down and no adjournment. In your case, even if you are hospitalized.
No,
This is pending since 2022 matter, Mr. We told you that if you make a submission that my prayer for stay should be considered, it is reasonable. But he is saying additional AG was just now here, right? You want us to repeat, right? You want us to repeat on his behalf and to make it look that court is seeking adjournment.
I am fine.
Yes.
I am fine with that.
Please argue.
I am fine with that.
No, we don't want any adjournment. Go ahead. Please argue. Mr. Senior Counsel, your case, what do we do? He is insisting for argument in his case. What do we do to your case?
It's a catch-22 situation for me. Catch-22 situation for me.
So you tell, because you are at.
I don't want to oppose the adjournment. I don't oppose the
No, but your friend is opposing adjournment. So that's the problem for us. So 45, what do we do? You tell us.
No, I would request your Lordship to fix some date next week, any day.
In your case. In your case.
In my case.
His case also we have. His case we are hearing today and deciding.
Your Lordship may not be able to segregate them in that manner.
No. See, next week we will hear your case and pronounce the judgment in both the cases simultaneously. That's the only thing. But he is impatient like a young boy. So we can't this thing, no? Countenance, what can be done? So item number 107 WPPIL 45 but adjournment, how are you aggrieved by it? That you want it to be heard today itself. Why? Now, you have been set up by somebody, right?
No, Your Lordship.
So if we start asking you, you will find it difficult, Mr. Better read our judgment which we have delivered recently, tracing the entire law of public interest litigation and how Supreme Court has approved the principles laid down in Balwant Singh Chofal. If we apply those tests, we are sure that your petition will be dismissed right away on the locus. These people are not prepared. All they do is seeking time. You better read the judgment. It is available.
Grateful, Your Lordship.
This is a public interest litigation. You should be in a position to play a constructive role, not like adversarial litigation, which gives an impression to us that you are set up by somebody else. It's not your land.
No, Your
You are not going to get it even if the petition is allowed today.
No,
What
sir.
is the anxiety? Tell us. It's not that petition has been, it's pending since 22.
It's been pending for last 5 days. It is being continuously adjourned, not for anybody's fault. But I've been waiting for.
What adjourned means we are telling you, you are trying to blame the court. We were hearing admission. We have sat beyond court hours to ensure that the admission of medical students, which is a time-bound process, those cases are heard. So you go to Supreme Court, right? That the High Court is not hearing my case. 5 days it is adjourning. Go. This is the allegation you want to make against the court, right?
I'm not
That
making
5
any
days.
allegation there.
It is not 5 days. It is only the 4th day in the week. So Sunday you are including. Sunday this case was not there in the list.
It has been in the list from
See,
Wednesday.
the matter has not reached, we have not given a date. Matter, board is continuing. We are, every day when we raise, we tell the court that the board will continue tomorrow. So that is how the board is continuing.
Yes, sir.
Yes.
I'm not.
No. So note down his name. In all his cases, we will adjourn if it is not taken up. So he need not make a statement that it is not taken up for 5 days. Write his name. What's your name? Please give. I don't know you. We don't know, but give a name. We will adjourn all your cases.
I apologize, Your Lordship. My intention is not to.
Mr. PSP Suresh Kumar was Mr. T. Suhasini. No, Miss. What's his name? Learned counsel for the petitioner. Mr. Sridhar, learned counsel for the petitioner. Mr. What's your name?
Sanjeev Kumar, special
Sanjeev
government.
Kumar prays for adjournment on the ground that the matter has been argued by additional advocate general. The aforesaid prayer has not been graciously opposed by learned counsel for the appellant. List on. Eleven 2023. 11th September. Item number 108. What's your name?
Sudhakar.
Maybe an earlier date would be more convenient for them. This
We see we have this.
I'll leave to the court.
Again, he will say 5 days. Getting reported.
Important for.
And we will consider replacing you, Mr. on the next date, right? This is a public interest litigation. Sheila Barse, you don't have a locus. Read Sheila Barse and our recent judgment. You don't have a locus to create nuisance, right, in the court. Mr. So and so, learned counsel. Same prayer.
Yes.
The aforesaid prayer has been opposed by learned counsel for the petitioner, and it is submitted that his arguments be heard today itself. It is further submitted be heard today itself. Paragraph. The issue involved in this public interest litigation is similar to the one in WP Bill 45 of 2022, which has been adjourned to 11th of September 23. Therefore, it is not possible to hear and decide this writ petition today. Notwithstanding the opposition by learned counsel for the petitioner, hearing of this petition is also deferred to 11th of September 23. Certified copy of the order be delivered to the counsel for the petitioner today itself.
Grateful.
We could have written more, but you read Sheila Barse, 88 Supreme Court. Come. 109. The writ petition has already been admitted for hearing on 7/8/2023. Let the same be listed in its in due course. Oh, yes, Mr.
Wait, Lord.
Yes.
This is a matter where the state of Telangana and Telangana Corporation, they have filed this petition against direction issued by the central government purporting to be under section 92 of the Reorganization Act. Now, therefore, this will need some time. I don't know whether whatever. I have
So
the
please, Mr.
I have
Mr. Vaidyanathan, whenever you come here, please feel free to mention the matter because see, we saw you sitting here, you did not mention. We always give, you know, you have appeared for me in we have always given you this thing there also because we always give outstation councils preference. So you could have mentioned, right? This PIL and all that, we are wasting time on unproductive orders. You have seen just now. It's better that we would have heard you. But please mention next time when you are here. Please feel free to mention so that we take it up. So today, of course, 5 minutes. It's not possible even if you commence.
That's right.
And Friday and Saturday.
A set of written submission. I don't know whether my lords have it. On the last occasion when the matter was argued, Millard, before another bench, we had given some written submissions. List of dates and written submissions. Right.
So what is, you can just briefly tell us what is,
Yes,
like,
I'll give a
brief idea.
Millard, in 2014, when the two states, Millard, two new states came in, there were certain agreements which had been entered into in regard to supply of electricity by the generating company to the distribution companies. Andhra Pradesh generating company sought to disrupt that supply under the power purchase agreement. Section 92 of the Reorganization Act says that existing arrangements will have to be continued. Therefore, Millard, the Load Dispatch Center gave a direction to them, you can't do this, you'll have to continue to do this. We took up a dispute before the Millard State Electricity Regulatory Commission. Regulatory Commission also came down heavily on the Andhra Pradesh Genco. Now, Millard, this continued till 2017, some supplies were made, some payments were being made. Millard, as on date, according to us, about 20,000 to 21,000 crore is due from AP Gencos and distribution companies to the Telangana entities. According to the AP Genco, about 3,600 crore principal plus interest about 3,500 crores is due to them, around 7,200 crore. But we are entitled to set off, in which case we still have to receive about 15,000 crore is our case. Now, they make a representation to central government and central government takes up only the claim of AP Genco and says that the documents have not been produced by Telangana, whereas Telangana was not even heard. And therefore, on that basis, an order is issued saying that under section 92, a direction to state. State was never involved. State did not receive the power. It was the distribution company which received the power. It was the distribution company which received the power, and no direction can be issued under section 92 to any of the distribution companies or generation companies. Therefore, we have come forward with this petition alleging violation of natural justice, that central government does not have judicial power, cannot take over the judicial power of adjudicating the claims of the two parties. That is a power, under the separation of power, exclusively vested in the judiciary, independent judiciary. Therefore, either the regulatory commission will have to decide or the civil court will have to decide. And when you go before either of them, they file a writ petition. AP Genco filed 2 writ petitions, they withdrew because the central government.
But probably this thing, we have not had the occasion to see this Act 2014.
Yes.
extensively. But in my parent state in Madhya Pradesh also,
Yes.
there was the reorganization
Yes.
was there.
Yes.
So that act probably contains a forum where there is that act. I don't know about this
Distribution of assets.
assets and this
Yes.
some forum
Yes.
which decides the claim
That's right.
what like.
In fact, Milord, I had occasion to appear on behalf of State of Madhya Pradesh, Milord, in regard to the electricity distribution subsidies also.
Yes, yes.
In the before.
Yes.
Milord, I'll place all those cases, Milord, I'll deal with that. Therefore, Milord, yes, there is a forum.
So
There is a
what you say is that there has to be an adjudication by some forum.
Yes,
That according to you is different, like it may be called some commission or
committee. There
committee.
is a committee which has
Committee.
gone into it, which has now deferred consideration.
There has to be adjudication by the committee or a competent civil court. Secondly, that has to be in consonance with natural justice in as much as you have to be noticed and heard.
Correct.
That's it.
That's a broad, sir.
I'm appealing for.
I don't have to cite many. My lords are familiar with this. And Milord, I don't have to cite the case law on administrative law. My lords have written a book. Similarly, interpretation of statute also I don't have. Therefore, Milord, my job is simpler before my lords. Milord. Any date, Milord, I'll take about 2 hours to set out the facts and thought.
2 hours, Mr.
Because the facts, some facts are some, and I have to read some documents.
We hope that you give us like she has not, madam, got the synopsis.
I have read the propositions, Milord. I will again
List of dates and propositions, so it will probably will be able to move.
Milord, I will circulate in advance, Milord.
Yes.
I'll circulate.
Yes, so what date you, this thing?
What your lordship consider in the week starting 11th, Milord, it is subject to my lord's convenience.
Yes.
The week of 11th September.
We can have it on 12th September.
I'm grateful.
May I make a submission?
One minute. This is something. So, yes, who appears?
But I'm appearing for the fifth respondent.
Yes, yes, Mr. Sriram. He is now, it's 4:30. So, he just briefed us what is this case, and now obviously it has to be, he is proposing 12th of September. Is it okay with you, 12th September?
Mr. Mohan Reddy is representing respondent number 5, and I wish to appear for the respondent number 2. Yes, Mr. Vaidyanathan Milords is traveling, and as your lordships have indicated,
No, 12th is an agreed date, or you want some other date?
12th, in case your lordship.
12th September.
If your lordships can give an earlier date, that would be an amount of 6,000 crores,
No, that is all right, but this is all subject to the cases which are already, we want to be realistic, right? Not give you a date in the future and then same thing at 30. That's why.
I beg your pardon. I beg your lordship's pardon.
Friday is 12th, 12th, Mr. 12th September.
If your lordships can consider, my lord, an earlier date.
No, Mr. Mondadi. The board is full actually, the board is full. Otherwise, you see what happens, matter will only reach at 4:30 or 4:15. It will serve no purpose. Why we have mentioned 12th is, even if it has to spill over to the next day also, we can accommodate. There is a cushioning.
And with the liberty to any one of the parties to mention at around 3 o'clock. Right? That is, we are telling everyone that liberty is there. If he comes, you please mention at around 3 o'clock.
We'll do that.
We begin the hearing.
I'll leave to you, lordships.
Huh? That's even with the activity. No. 12th September, Mr. Vaidyanath, learned senior counsel for the petitioner, mark Mr. Yes,
Respondent number 2, my lords.
My lord,
everybody's presence you mark.
one submission, my lord.
And Mr. You had to produce the record, right?
Yes, my lord. The record is here, my lord.
You please produce it on the next date of hearing. 12th September. You retain it with you. There is an order we noticed on 27th April. Mark their presence, Mr. Reddy, learned Mr. What? Mr. Reddy and Mr. Sriram.
And for respondent number 1, my lord, additional Solicitor General, Mr. Sundaresan is also there. Yes.
On account of paucity of time, the matter could not be taken up today. List on 12th of September 2023. Parties are granted the liberty to mention the matter. Yes, next. All madam.
1/1/2022, 134.
This matter, my lord, the lordships had called for a report from the member secretary.
112 to 124.
Report was called for, but
112 to 124.
this is
No,
concerning,
Mr.
concerning one of the water bodies, my lord. A report was called for, my lord, to the member secretary.
State Legal Services.
Yes. The report was, I'm told my report is already submitted to my lords.
Steel cover, madam.
With regards to the constructions, if any, have been undertaken by the respondents subsequent to the status quo orders passed. That was the report which was called.
Open. We will see that. See.
Signed submission, my lordship. In the item number 120, I am for the petition, my lordship.
1 minute. This is public interest litigation, not an adversarial sort of litigation, right? That's what we told one counsel. He's sitting here, Mr.
Yes.
Don't follow his footsteps. We want to this thing, right? Address the issue. That's why we have directed the member secretary to give a report. Yes, just now you have seen that it is open.
Yes, yes.
You want an adjournment, right?
No.
Then-
I'm just representing.
Wait. The court will not pass any order against you without hearing you.
Yes.
Separated the report. Yeah, carried out in violation of the orders. Where is the it should accept that these 14 have we will take action. We will be GHMC. You appear for GHMC?
In fact, the Advocate General was appearing earlier in all these matters.
No, see, Mr. What we have found from the report is just now opened in your. There are 14 illegal constructions in buffer zone. Monthly tech zone doesn't permit and nobody can do it even otherwise. So you have to take action.
May I request one?
Don't give them a long rope so as to and tell them. We have come across several lakes in Bangalore where authorities we used to tell that don't give them a long rope and suggest that go to court and obtain stay so that we are bound.
You are bound to follow the directions of the court.
No. So you see, the report says there are 14 illegal constructions in buffer zone area.
May I request?
You take action.
Separate
You means who?
Not subject to your lordship's pleasure. Suppose a copy of the report is given to me, to better assist the court, and also give appropriate directions also. That's all. Independent writ petitions were also filed. Independent writ petitions.
In compliance of the order dated 5/6/2023, passed by division bench of this passed by a bench of this court, the member secretary of Telangana State Legal Services Authority has inspected the Malcolm Cheruvu and Lake and has submitted a report with regard to the construction on the buffer zone of the lake, full stop. The lake, in a CD cover. Paragraph today, we have counsel for the petitioners as well as learned Mr. Prasad, learned counsel who represents so and so, as well as counsel for GHMC. Correct?
It's a copy.
GHMC within a week. You have to take action, Mr. With the assistance of Mr. Prasad. You have to take action. Within a week. Let the writ petitions be listed thereafter. Keep it, madam.
The input copy may be given to the respondent. I am telling you the respondent. Writ petitioners.
We have said learned counsel for petitioners and Mr. Prasad. You are not petitioner.
No, for the.
You are an encroacher, right?
No, I am there. No, I am the respondents. I am the writ petitioners before the learned single judge. I succeeded to learn a single judge.
You said learned counsel for the parties, which
Much
include everyone.
Much obliged.
Place thereof. Now, do you need to make any submission? No. Madam, keep it in a staple this thing, the report. And again seal it and then this one. Again seal it and then we will see on the next day.
Because fixing a date, madam.
Date?
Any specific date?
What happens that you will again seek an adjournment at this on that day. That's why we are not. As soon as you are ready with the given the report,
I'll make
and you are ready with the start taking action. Don't wait for us. See, Mister, there are 14 encroachments. That indicates his impatience, indicates he is the encroacher. He knows. So there are 14 encroachments on the buffer zone. In view of Mantri Tech zone, it cannot stand. You have to take an action for removal of encroachment. You file a status action taken report on the next date of hearing.
Subject to correction, my lord, there are independent writ petitions also filed. Interim orders are granted. I'll bring it to my lord's notice.
In though obviously you will action taken report, you will say 4 petitioners have filed writ petition.
I will.
Remaining 10 are drafting the petition. Lighter when Mr. Prasad, we hope at least that you will at least smile at 4. They are so tense, right? As if it belongs to lake, belongs to them, and they will take it away. These petitioners, so seriously. You are a petitioner, right? Your grievance says that the lake is being encroached, or you want to encroach the land.
Lake is getting encroached, my lord.
So we are doing it, right? That's why, and we have supplied, we have direction. We are asking him to take action.
I may make simple request. No?
He cannot go. You go there and remove construction.
So far as the Aminpur Lake is concerned, no FTA is fixed as on today, my lord. That is a declaration by the single judge. So far as Aminpur Lake is concerned, that is the petitioners. So far as no FTA is fixed by the authorities, my lord.
That they will fix council. He is under already this thing. FTL you have to notify, right? Then take note of this that no is fixed. Which lake?
Aminpur Lake.
Aminpur Lake. Which case, Mr.?
Item number 117, 118.
117, 118, you right? The dispute in this 117, 18. In dispute in this writ appeal pertains to Aminpur Lake. Learned counsel for the respondents.
Yes.
Respondents in the aforesaid appeals submit that the FTL level has not, in respect of Aminpur Lake, situate within the limits of this thing. HMDA has not been notified. In view of aforesaid submission, Mr. So-and-so states that a notification in respect of aforesaid lake notifying the FTL level shall be issued. Preliminary notification shall be issued on or before next date of hearing. Note down, Mr. You have got such beautiful pens, red and the green one, we believe. Note down, otherwise you will forget. And these people, your clients will land in trouble.
Yes, sir.
Note down. Next date, Aminpur Lake, you have to issue a preliminary notification. Correct?
Update you lost.
List after 2 weeks. You are anybody is at liberty.
I'll make it.
Once you initiate the action, tell us why. Because see, again 124 cases how listed, and because of this, any other case, we find it very this thing that old appeals are not coming up for hearing.
After the action taken, a report to the courts.
Yes.
I'll make a mention to.
So it should not come up in final hearing, it has come up on a motion hearing. Yes, correct.
That was deeply obliged.
Yes.
My lords, in this matter, Advocate General is appearing, my lords, requested to fix some date, my lords. It requires some time for hearing, my lords.
And for the respondent.
Mr. So and so prays for short accommodation. List one.
Next one.
20th September 23. Yes. 26, 126.
May it please your lordship. And for the appellant in item number 127, my lord.
120?
For 127, I'm the appellant from.
Yes, what is it?
Matter pertains to the Halafnama affidavit, my lord, the unregistered affidavit, my lord. It was partly argued by my colleague in the previous occasion. We have prepared a short synopsis for my lordship's consideration in this matter.
No, what is it? Tell us.
My lord,
Are brief, Mister. See the time.
Just short minute, madam.
You just tell us inform.
Section 2 of the transfer of AP schedule areas transfer regulation, my lord. We had the transfer happened in 1968, my lord. In 1970, there was an amendment which was brought in, which prohibited from non-tribal to non-tribal any transfer to be made. On the previous occasion, my
We are not asking you to argue, Mister. Just tell us. Forget. See, Mister, you are a young person. We will tell you one tip. You are appearing at 4:50, ready with the case, and you have filed a synopsis also. Therefore, we will tip you. We will give you a tip. You have a long way to go.
Yes.
Learn to rely on your memory, and it will never fail you. Right? Close it. Now tell us what is this thing.
My case in short, my lord, the Halafnama is a contract. The contract, there was a consideration, there was an offer, there was an acceptance, and there was a consideration. My lord previously told that it is not a registered instrument, because of which it cannot be considered under section 2G of the transfer of this act, my lord, the agency laws. We have judgments, and we are referring to this interpretation of statutes by my lordship himself, which shows that it is a contract, and the contract.
Yes, we remember it was argued.
Yes, my lord. Yes, my lord. It was argued in part with previous.
Yes, correct.
Are you responding, Professor?
Yeah.
So 27 July you did not appear. So we said
We had appeared, my lord.
thereafter.
We have waited on each occasion, my lord.
The
We are
order
able to argue the matters. We have been on each occasion present.
No, but order sheet something says 27 July none appears. May be wrong, but the
My lord, for
fact
item
remains.
127. That may be for the other item numbers, my lord.
Maybe. Again,
I'm
nobody.
appearing for item 127.
This is WP 219.
I'm for the 126 appellant. 126, item number 126 appellant.
WP 219. Yes, madam. WA.
Lord,
Ask her what is the submission.
my submission.
In your matter, what is your submission, madam?
Miller senior counsel now, he's out of station. He still now, till 4 o'clock online only. Just now he moved to,
Bombay.
no, Miller, he's coming to Hyderabad only. Actually, he's in airport. Actually, he's in airport, so he could not able to come in online. Just till 4 o'clock, he is in online only.
In my humble submission, my lord, on the previous occasion, these matters were not patched together.
1120. Yes, give madam his synopsis. We will keep in 1120. This is 2000. All right. This 1120 relates to Atilaba. Let WA 219 bar 2000, Learned Council for the Appellant prays for adjournment. Let this writ appeal be delinked from WA 1120 bar 2008 and be listed separately. What in view of prayer for adjournment when 2008? 2008 we can do 30th August. 30th August or 4th September. 4th September 2023. And your case also, his case also, his case you write on account of paucity of time, the appeal could not be taken on list on 4th of September.
Deeply obliged. I'm deeply obliged.
So that it shows that we don't record incorrect
Much obliged.
right? She must not have appeared.
I have appeared, my lord. We have always appeared in the
In
matter.
your case, we remember that this has been argued.
Yes, my lord. We've been arguing in part. I'm ready with my judgments and the argument too, my lord.
Much obliged.
Much.
See the time.
Sorry, apologies.
You should be alive to the situation also, right?
Deeply obliged.
You are ready, fine. That doesn't mean that we will sit till 12:30. Nobody is being hanged. Right?
We'll
Like
brief,
Supreme Court assembled no urgently because why? And pronounced judgment. Nothing is happening of that sort.
I'm obliged.
Except the fact that you are ready.
Obliged.
We'll consider interesting point. Yes.
Deeply obliged.
It's all 23 matters. Array, Mr. Prabhakar, why it has come up 2023 petition for final hearing?
Yes. Teacher transfers rules, Milord. Ships.
Because you see, the grievance is that all this thing transfers have come to a standstill.
Yes.
And there is a stay.
The stay, my lad, the stay granted on
And
the base.
government is very anxious in effective
Yes,
transfer.
because the elections are there, Milord. Prior to that, they need to do.
Not election, nothing to do election. Imparting quality education.
Array, this is, we all understand. Okay. It's all we understand. This all lighter vein is saying here, they have not even opened the file, nothing. So why should you resist what Mr. Prabhakar even says
my
on the
best
lighter
friend.
side?
He's my
You-
best friend.
No, therefore you should. So what did you say, Mr. Prabhakar?
Lordships.
All right. So what is this?
Issue is there that Milord already 317 GO in the year 2021 were issued, Milord, and transferred the
Array, Mr. Have you
teachers.
counterfeit?
Again, this has been issued.
Counterfeit?
Counters filed.
Where is
Well, counter accompanied by vacate stay petition had been filed on your account. On 14/2/2023, an interim day.
10 special points for teachers whose spouses are working in central state government or public sector undertaking local body.
This is the violation of doctrine of equality and doctrine of equity also, Milord.
No, sir. We don't know whether doctrine of equality applies or not. They will argue.
No, Milord.
No, in case of the spouses who are like the persons who are having spouses working in state, central government or any public sector undertaking, what he will argue is it's a different class.
Yes, synopsis.
And therefore entitled
for your
to.
last candidate, synopsis have already been prepared. Which is
I filed my written submission.
This is Mr. Prabhakar, your synopsis.
Yes.
First line is not necessary. We are always pleased, right? When you give synopsis, we are always very happy. Yes. So first line you need not write. Next synopsis.
Deeply obliged.
Yes. Yes, yes.
Yes, Lordship, so.
Arbitrary, discriminatory, irrational, unreasonable, procedural impropriety, illegal.
In two aspects, my lord. One is teachers associations leaders are being provided 10 points extra, my lord, in transfer. And the second spouse, my lord, within the district, which recently districts have been formed not even 100 kilometers radius. In the spouse, in among all the districts have not been providing those 10 points. Only within the district is the both contentions are mirrored in the rules are violating the Article 14, 16, 21 of the Constitution of India, Millard, and irration also is there, Millard, and discriminatory also is there, Millard. My humble submission with great respect to this Honorable Court, I have categorically stated one.
Stay has been granted by this court.
Paragraph 6, Millard, I have.
1 minute. Stay has been granted.
By this court.
Which one?
On 14/2/2023, stay was granted, my lord.
What you were doing for 6 months, Mr.
My lord, I had been insisting upon him, my lord.
No, I have not been here for 6 months.
That's true, my lord. Even before your lordship came,
They were only
yes.
5 weeks.
Immediately, within no time.
Next week on.
In March, we immediately filed the counter,
Well,
my
there is
lord.
no stay order here. This case.
There is a stay.
Maybe we stand matter without stay.
Last date, some petitioners
Not
from
in
council.
not, my lord. In yes. Just, my lord, the stay granted on the ground, the rules were not laid in the assembly. Subsequently, rules were also laid before the assembly. That was one of the ground on which
Mr. This, we will list it for vacate stay petition on 30th August, Mr. Prabhakar.
Lordships,
30th August.
your Lordship, sir.
Yes, only.
Yes, because everything can't be like decided every case finally because stay has been granted. You argue on vacating stay.
Yes, I will.
Let these appeals. 1 minute.
I have a submission.
1 minute. Let these appeals be listed for consideration of.
Millard, I have a submission. Sorry. My case, I am representing petitioner in
1 minute. You can say later on, not necessary to interrupt when the court is dictating an order. You can say later on
I'm sorry.
that my case is different. I don't want this thing on Monday. Some whatever.
Publish.
Let the IA be listed for IA filed. In this case, 285, all cases you have filed IA.
On in petition number 3962 of 2023, my lord. In which
2856.
yes, 3962 of 2020.
Don't confuse number, serial number.
Item 132.
130. In this case, my lord, initially stay granted.
This is not filed. That's what I'm saying. So, Mr. This indicates, the list indicates that you have not filed any vacate in 129. Your vacate is 130 and
In 132, item number 132, my lord.
these two cases will be listed.
Yes.
All right. Yes. Huh?
132.
Okay. 130. Rest everybody should enjoy, right? In their cases, government doesn't want vacation. If you are.
Those who stay at us.
That's right. So we will list these two matters. 130 and 132. You write these two. Let these appeals, let these writ petition be listed for consideration of IA number 2 of 23 and 8 of 23.
5 and 6 also. 5 is there.
5 is implead.
Implead and 6 for vacate.
So you write, Mr. Delete item 130, you write. Let this petition be listed on 30th August 2023 for consideration of IA number 2 of 23, right? Then by 132. let this appeal be listed for consideration of IA number 5, 6 and 8, 2023, 132 on 30th August 23. Correct?
230.
So you argue
Yes.
on vacate petition.
Yes. And at 230.
So,
230, Your Lordship.
whatever 30, mention on that day, not at 10:30 and forget about it. Mention at 2:30 like this.
Yes, Lordship.
We don't know, vacate means it may come early also in motion hearing. So if you are not there, then it is adjourned.
I will be there. I'm always here to assist Your Lordship.
No, one case,
It will be under interlocutory caption.
under interlocutory caption.
It will be under interlocutory caption, not for final hearing. So
Yes,
it will be better.
Yes.
It will come.
That's all.
I have submitted synopsis to my lead friend,
yes.
Advocate General.
Yes. You prepare on vacating stay, Mr. Prabhakar. You tell us why stay should not be vacated. Correct?
I like the matter.
The other 3 matters in this batch will be posted.
So other 3 cases, yes, now what are you saying?
Right.
You are appearing in which item?
Item 133, my lord. This writ petition filed for the reservations in promotions, my lord.
This has nothing to do with this teacher recruitment batch.
I mean, my lord, the same GO is challenged because the GO is not disclosed the process to be followed for the implementation of reservation. Well, after filing the writ, the respondent filed a counter stating that they are following reservations on so and so GO basis. Among those GOs, my lord, only one GO number 2 is in problematic, my lord. I will take only 10 minutes, my lord. My lordship may take it on 28th, my lord, or 1st September.
No, why this 133 for final hearing 23 matter, why it should be heard finally? Tell us. Why? You tell us why a litigant who is waiting in this court since 2005 should not be heard. Why what is the justification for hearing a litigant out of turn who has come 18 years thereafter? Tell us as an officer of the court. Monday, Tuesday, you are saying it be heard. I will take 10 minutes. Why? Why that 10 minutes should not be given to litigant who is waiting since 2005? Please tell.
The GO 5 and 9 issued.
Please tell. Where is the order of listing it for final hearing? Nothing. Item number
133.
130. This thing serial number WP 70911 2023. Pleadings are complete, Mr. Counter is not filed.
Counter filed to that.
Counter filed, Madam 133. You want to file any reply?
No, my lord.
No. The counter, this thing 133. The counter in the instant writ petition has been filed on behalf of respondents. Counsel for the petitioner submits that he doesn't want to file any reply to the counter filed on behalf of respondents. Line below, the petition is admitted for hearing. Let the same be listed in usual courts. Yes. Which other case? 130 and 132.
I am sorry, my lord.
131. What happens?
133 listed on what?
Usual courts admitted for hearing. It has not been admitted for hearing so far. This is strange that without any order, the cases are coming up for final hearing. Your writ petition has not been admitted. That shows that how to what an extent the things can be managed. 129 was yes 129. Give 129, madam.
139, I filed a little submission.
Just a minute. 129. Come here. What is 129, Mr.?
My lord, 130.
There is no stay in your case.
Challenging the 10 point, granting 10 points.
Same, Mr. Prabhakar. Same. There is no. In your case, there is no stay. Consequently, government has not filed any vacating stay. So we will admit your petition. Pleadings are complete.
Pleadings are complete. I filed written submission.
Just a minute. No, that's correct. Petition is. You don't want to file any reply.
I filed a written submissions, my lord.
No, you don't want. Counter has been filed.
Counter filed.
don't want to file any
No,
reply.
it's no
Heard on the
reply,
question of admission, petition is admitted for hearing. No, it's already 14.8. The order sheet indicates that the petition has already been admitted for hearing on 14/8/2023. Let the same be listed for final hearing in due course. Yes. 131. 131, Madam, give. Hmm. Petition has already been admitted for hearing. Let the same be listed in due course. Yes. Only two cases vacating stay we will hear. These petitions will come up for hearing along with his Mr. Prabhakar's case.
Lordship's pen permission. Lordship's pen permission.
Yes.
One content case is pending, Lordship, that is transferred from APAT to this honorable court. That is pending, Lordship. I have given representations also. The case is not listing. My humble submission direct the office to.
No, Mr. What is the time of making a mention in this court?
Sorry.
What is the time? 10 minutes past 5 p.m.
It is a matter.
You don't he stay here in Hyderabad. You don't stay here.
Yes, Lordship. Yes, Lordship, I am staying in Hyderabad.
Then 10:30 Monday.
Having some physical problem, that's why I am not.
No, physical problem. That's why 10 minutes 5 or 10 minutes past. This is not. Mr. Prabhakar, please explain to him that he is required to mention the matter, anybody at 10:30 a.m. in the morning. And he can do so on Monday.
Yes.
you.